सी
ମାନେ ଏଠି ଅର୍ଜେଣ୍ଟ ଇଏ 30 ତାରିଖ ଡେଟ୍ ଅଛି ତା ୱାଇଫର ଦେହ ଭୀଷଣ ଖରାପ ସେ ପାଇଁ ସେ ମାନେ 30 ତାରିଖ ସରେଣ୍ଡର କରିପାରିବେ।
I'll see everything. Note it down. I'll see everything.
Criminal opinion.
I will definitely. I'll see.
I will be pardoned to mention this matter because why I am mentioning it was directed on
Whatever you are mentioning, you must write so that I can see it. You must write that so that I can see
Yes, I have written. 23rd May, it was directed to be listed because it is D number, so that they are not listing the matter. Small matter on this PT trial, your lordship was convinced to pass the order on D number, but they are neither they are putting the case number, nor they are listing. No D number will be listed.
Okay.
One CRA your lordship 10 ବର୍ଷ ରହିଲା.
But you note down in the top of the memo. You note down so that I can understand what exactly.
No, I will be pardoned. I have challenged the entire proceedings under the CML Act because in the meantime, the predicate offences in the vigilance case I have been discharged. I have not been found sufficient in the charge sheet itself, and there will be no appeal whatsoever, my lords, against that. And hence, I have prayed for my discharge also in the KMLA matter.
5 years conviction of more than 2 years.
Have you written everything,
Yes.
sir?
Any mention from page?
Give memo.
More than 10 years.
I think.
9 years, 10 years.
Yes. Yes.
Item 1 to 5.
Item 2, my lord.
Yes.
Not huge time.
Is there any stay?
No, my lord.
September. Yes. next.
Lordship, item number 1.
Item.
Item number 1.
One.
Some time for instruction from the client.
Any? This is the 138.
Item 1.
138.
Yes, sir. 138.
Oh, 138 matters. Why? What instruction? Are you enjoying a stay?
Lordship, there is no instruction from.
Is there any stay?
No, your lordship. No.
Item number 4, my lord.
Yes.
Kindly taken up 1 week after, my lord.
Is there any stay?
No, my lord, no stay.
Item 6 to 15.
Item number 3.
3.
Yes.
Yes.
The learned senior counsel, Mr. Asukmati has requested for time.
What do you want, madam?
A 1 week adjournment.
Okay. Wonderful. Is there any stay? No stay?
No stay.
Okay.
Obtain for that.
Yes.
Item 6 to 15. Item 16 to 24.
My lord, item 22.
Yes. What do you want?
23. No instruction. Item 23, no instruction.
What about 22? You are on 23 or 22?
My lord, 23.
Okay. Clear.
1, 2, 2.
Submit that to me.
2017.
That matter accordingly you want to place the same. Yes. Yes. Disposal. Okay, next.
25 to 34. 35 to 42. 36 days
Withdraw 36. Yes.
43.
And item 44. There is my power is there. So I will make taken some of the I will intimate to engage with the
Look.
44.
44. Huh? Yes.
44 to 48. 49 to 54. 55 to 61. 62 to 65.
At 64, this is transfer brief. I have to obtain the entire.
Okay.
Next week, any day.
That takes a good see. Yes.
66 to 70. 71 to 79.
73 not present.
73 not placed.
Sir, Lordship, item number 74. Lordship, item number 74, I pray for a short adjournment. My senior is not present today.
74. Is there any stay?
No, Lordship, entry will continue.
Entry will leave that. Wait. Yes. Next.
80 to 88.
Right, thanks. Mr. Millard, 84. I've got the opposite party, number 2, wife.
Hmm.
Millard, the mediation was failed.
And this matter, not there is a proposal of last occasion, it was in before the Honorable Coordinator bench. Since mediation failed, so my lord, may I request your lordship that the mediation, because husband is staying in America, wife is, if your lordship will take another chance endeavor to attempt if any mediation can be done by the instance of your lordships.
Let us see who is appearing.
My lord, sir.
Chief also directed to appear through virtually also.
Yes.
Yes.
Now, husband also appear through virtually also.
Mhm.
Your lordship.
If your lordship.
What is the dispute?
Dispute matrimony.
In-laws. In-laws. That 490 case with her. You also refer the matter to.
The husband is staying in
Staying
USA
abroad.
and wife is here.
Proud clear. There is a child. There is some multiple cases are there. If lordship may kindly take endeavor.
So why you are appearing for the husband?
No, wife.
Wife.
Husband's petitioner. Only with the father-in-law, mother-in-law, and brother-in-law. Your
So
lordship.
why are you not settling?
My lord, if lordship may kindly take up, if your lordship may kindly, that we by your lordship it can be resolved or any.
Well, let it come. Then I will ask them to appear before this court through
Yes.
which mode. I'll just see. I'll try to find out way.
So some other day, because he has to inform the America, his client.
You tell me the date.
Date.
You speak to him and tell me the date. I'll fix it. Both the parties to appear
Yes.
before this court in VC mode.
We intend coordinate with the.
Huh.
On that day.
We'll fix the date.
Right.
Or his
Council is appearing for the parties submit that although the mediation the mediation attempt has already been failed, but they see there is a scope of out of court settlement, regarding head to the statement by both the councils together before this court. I feel it appropriate to direct the parties to appear before this court through VC mode on the next date appeal, so as to explore a possibility of settlement. You tell me the date when.
Yes.
When do you want? You tell me the date, Naresh.
Date.
Which date you want?
Yes.
What is phone name?
That was last one. Fixed with the next day also. On that day.
You tell me when can. 7th?
29 to 30, 31st.
31st of
This one, 31st.
31st, huh?
7th ରେ ଆସିବ ହେଇଯିବ ସେଟା ଟାଇମ୍ ନେଇଯିବ.
Let it be 7th August.
7th, yes.
7th August.
Grateful.
Both the parties to appear.
Appear.
Then we will interact and see.
Yes.
Entry mode to continue. Yes.
Item 80. On behalf of Mr. Mishra, I am praying for an adjournment to file a compromise agreement.
A settlement has been arrived. Land Council appearing for the parties. You have a petitioner? What is your name? It is Mr. appearing for Arijit Mishra. Submit that parties have settled the dispute. She seeks an adjournment to file a joint affidavit. Joint affidavit, please the matter on 3rd of August. 3rd August, yes.
Item 89.
Item 54. I have.
Yes, 54, what do you want?
I pay for next week.
Is there any stay?
No, what a bail, my lord. Criminal appeal.
Okay,
Yes.
okay.
Bail.
Yep.
My lord, face bail,
Give
criminal appeal.
Yes. The matter which is listed, you are not interested, and you want to get further matter listed.
ନାଇଁ ଆଜ୍ଞା ସବୁ ସମୟରେ କଣ ସବୁ କଥା
ଯୋଉ matter ଅଛି ସେଇଟା ତ ଆର୍ଗୁ କରନ୍ତୁ.
ହଁ ଯୋଉଟା ଅଛି ଆଜ୍ଞା ମୁଁ ତାକୁ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ କରିଥିଲି ତାଙ୍କର ଇଏ ଥିଲା ସେରିମନି.
Okay, we'll see.
ହଁ ସେଇଟା ଅଲରେଡି
Okay.
କଣ ହେଲାଣି ଟିକେ
Okay, sorry. Yes. Let us start.
I may be pardoned. The other weekly list, the second weekly list, item number 12, we have filed our wakalatnama to demolish. I am only praying.
We'll
that
see.
it-
Let's why. No, don't worry.
A name may be different.
Yes. Yes. Next. Start.
Weekly daily, item 5.
Jail criminal appeal.
Yes.
Last occasion, Honorable Court engaged, as per the order of the some of the council has been engaged.
Who was engaged?
Yeshurun Nisha.
The registry is directed to
The registry be directed to prepare the
Who has been engaged, SC?
376, 294,
Not it,
506.
but who has been engaged now?
The cashier name is appearing in the record list.
Appearing.
The paperwork is required otherwise. Only letter petition.
That's the problem. The amicus curiae name is appearing, is not coming in. It's not.
I will intimate me some.
I'll change the, if this kind of the amicus curiae have works twice, thrice, otherwise I'll pass an order to drop their name from the list. Amicus curiae matter means you should give much more importance than the other three. That's not. What is the use of then? Right of pursuant to the order dated 18/12/2025, Mrs. Nisa has been appointed to appear for the appellant, appointed by the Legal Services Authority for appearing for the appellant. His name, her name is also reflected in the call. However, unfortunately, she is not present today. It is in the interest of justice, the matter is urgent to 5th of August.
Date, my lord?
5th August.
5th. I will also convey.
It is made clear that on the next date of hearing, if the amicus curiae doesn't appear, she will be dropped. She will be dropped from this list. She will be dropped from this case. And another will be appointed. Yes. Yes, next.
Item 6.
6.
Item 6, I am appearing through BC.
Your Lordship, I am appearing for the Income Tax Department. Let a copy may be served to us.
And that copy is served to state. I will be provide my print. So it will submit. Always the council appellants of the state, but state is the FEMA and
Mr. Gedia, you please collect it.
Yeah, Lordship. Your Lordship.
Okay. I'll just list it on 12th of August.
Your Lordship.
Okay. 12th August. Okay. Yes, next.
Item 7.
Yes.
7th is a vigilance.
Against conviction, my lord.
Yes.
Your lordship wanted to know on the date of judgment.
It's not even admitted. It is not admitted yet.
No.
Huh?
That I pray for bail. And your lordship.
The appeal has not yet been admitted.
Yes, ma'am. Your lordship wanted to know last week in this case that what order have been passed by the learned court below while granting bail, ma'am. That bail for the
3.
Order dated 1/5/26.
It was suspended up till
from the appellate court before expiry of the appeal period.
Okay, better. This appeal is rising out. The appellant is saying the judgment of conviction order the same is admitted for the years also, and application will be by the pending the appeal. The appellant is seeking suspension of the sentence. It is brought to the notice of the court that the sentence in court by invoking section 389(3) of CRPC has suspended the sentence till the appeal is preferred. Since the sentence is, what is the sentence?
2 years simple imprisonment.
Under
section 325.
2 years so is passed. And for the reasons stated in the application is now granted to the 20,000. Yes. Yes. Next.
Item 8.
Challenging the order passed by learned additional session judge from the special court. It is a matter SCST of SCST.
Admit in the IA issue notice. Issue notice 12th. Oh, you are in custody. 12th, huh? 12th. Yes.
And notice, my lord.
Fine to substitute. To be served through IU, huh?
Through IAC method.
IAC.
Item 9.
One of the act जो offense is POCSO.
POCSO notice. Notice has been issued? No.
No, first time.
Okay. Issue notice. Admit also being this thing. Issue notice. One of the offense being POCSO. And where is the delay? No delay. No delay. Take it. Yes. Realization state. Yes. Next.
Item 10.
Same also.
Same.
One of the POCSO.
Same order. Next.
During trial, I was on bail notice.
Notice I have issued.
And admission, my bail application will be confirmed.
I will release it on 20th of August. 20th August. Yes. Service. Huh?
21st.
21st. 21st.
21st.
19th. 19 Wednesday. Huh? 19 August. Through IIC service.
Yes.
Yes.
Extra from them.
Yes. Next.
Item 11.
May I please judge?
Yes.
I'm challenging the judgment dated 3/7/2026 also, where the PT appellant convicted 1 year under section 118 clause.
This application is for admit call for the diary to look into this thing, and in IA for the reasons stated in the application regarding head to a short sentence of 1 year awarded to this thing. Appellant, I'm inclined to suspend the sentence awarded to during the pendency of the appeal accordingly. Okay. Yes.
Obligers.
Item 12.
Well, challenging the judgment of conviction 12/5/2026, conviction of 498 for a period of 3 years. I am on bail on the very same day. I filed also on IA and
389 3 benefit was granted till the filing of the appeal.
Yes, my lord.
Shall I record it?
Yes, my lord.
Convicted and also appeal admitted. As also, I realize from state in so far the application is concerned. Learned Counsel Mr. Anjudu said that the counsel appealing for the appeal submits that the sentencing court by exercising power under section 389(3) for CRPC suspended the sentence awarded against the appeal till the filing of the KP. We further submits that during trial we were on bail.
Yes.
Trial,
That I don't reflect.
the convictions the reason stated in the application, and regarding it to the reason stated in the application, and the period of and the fact that we convicted on bail during the trial. Trial will be evidence and plan to suspend the sentence during the granted bail. Yes. Next.
Item 13.
May I please, Your Lordship? I'm in virtual mode, Your Lordship.
Yes.
Your Lordship, we have preferred this appeal against the order of conviction and judgment dated 30th of June 2026, Your Lordship. The
What is the
offense
sentence?
under which we are convicted is
POCSO.
section 12 of the POCSO Act, Your Lordship.
Okay.
Your Lordship,
Notice.
I am in bail, Your Lordship, and on 30th my bail period is going to over, Your Lordship. My liberty may kindly be...
I have issued notice because POCSO is there. Okay. Next.
Your Lordship, but my liberty will be...
Least on 21st.
My liberty may kindly be secured, Your Lordship. 30th is the last date. I'll be taken into custody, Your Lordship. I was enlarged on bail on the very day on which judgment...
30th of this month.
Yes, Your Lordship, yes.
Then notice has to go on. Let the notice go.
At least on interim measures, my liberty may kindly be protected, Your Lordship. Till the...
It's all right, but unless notice is issued in a POCSO conviction, I can't do it.
But I'll be taken into custody.
I can lease it on 31st. 30th. 30th. Okay.
30th of this month, Your Lordship. 30th August.
Sorry?
30th July.
I was giving 19th August.
No, 30th of July, Your Lordship. My bail period is going to over on 30th of this month, Your Lordship.
I understand, but unless the notice is served on the victim, I can't pass any order.
At least my liberty be prevented, my liberty be secured.
That's liberty only bail.
Interim measures.
Liberty only bail. For that only I need the other side to be there.
I know, Your Lordship, but I'll be taken into custody in that case. I was all along on bail, your lordship.
Then what can I do? Serve, take out the notice. You serve yourself and come. On 30th, I release it. 31st or 30th?
30th of
30th.
this month, your lordship, July, 30th July.
30th of July. Okay, you serve.
Gratefully, lordship.
Serve the victim. Okay.
A direction be passed in that respect. I'll take the notice to the victim, your lordship.
That's what I passed the order.
Gratefully, lordship.
Notice to be served through the IIC as well as IIC, Learned Counsel for the petitioner submits that the bail granted to the petitioner is likely is going to be expired on 30th of July. Hence, he would take steps himself to serve the victim public informant. Release the matter on 30th. Yes.
Urgent certified copy, your lordship.
Yes, next.
Item 14. Vigilance case. The appellants are sentenced for 1 year for the offense under section 13(2) reduced section 13(1)(e).
Realization.
Two petitioners are there, my lord. I am appearing through virtual, my lord. Husband and wife, both.
Okay. Record the statement. Experience and granted bail. Yes.
My lord, only your lordship may observe that till the disposal of the appeal, the sentence may be suspended because
that time I have already said.
Now likely sabu bond kar do.
Sentence only I can only suspend the sentence, not the conviction.
Not 389
sentence.
Unless sentence is suspended, they cannot be granted bail.
नहीं से बुझुला से कहले से प्रोविजन देखले बुझुना
की बुझुनांती
से माने सब डिपार्टमेंट वाला से कहउछन कोर्ट लेखि ना आंती हमें 389 का प्रोविजन देखि
My appearance may kindly be noted, my lord.
Yes.
Item 15.
Make legal lawsuits. My written note is flag C. On the last occasion, my written note there are some spelling mistakes. I have to bear the cost of this court. So I have corrected copy. I didn't corrected copy. Same thing, but corrected copy. Only spelling mistakes are corrected. My place in manners.
Yes.
The petitioner is a housewife. Her husband is a public servant. Both are charge sheeted on the 32 ready 31 is here.
You are challenging what?
My wife, housewife is become a abatement. That's the only charge against me. No material has been found out regarding the abatement. That's what I have explained. The only thing is that my husband.
You are seeking discharge or causing? What are you seeking?
Discharge. I am discharged.
Your application has been turned down.
Turned down.
Where is that order? Show me.
What?
Where is that order?
Not a whisper about it regarding the abatement.
Where is the order by which your application has been rejected?
Page 183.
183. Okay. Yes. What does it say?
We will also turn to internal page 2. Internal page 2.
Yes, I'm reading.
The order but a whisper about the abatement.
You are accused number 2. You are accused number 2. Who is appearing for vigilance? Yes. Has she put forth any defense herself?
She permits, my lord. She has that defense, my lord. So far, the petition, the wife abater is concerned. They specifically taken, and in fact, from the.
Has she tried to
Yes, my lord,
defend?
she
That
has.
part you show me? If she is putting forth any defense to justify the.
No, fiduciary relations with the husbands. Having her own income. No fiduciary relations.
If she says that I have own income and all, then he has to justify. There's no question of discharge.
I think your lordship
that is my judgment, which has already.
relations with the husband. My lord.
Show me that.
No income at all. Let us and absolutely penniless. Simply depend on the husband. My lords. Your lordship turn to page 178. My lords.
And 178. Yes.
The other materials are there, but I'll place this one. 178. Para 9. Your lordship turn to the second paragraph. Para 9.
Similarly, Srimati
Sulekha Marco, petition of lordship, daughter of Gointa, daughter-in-law of Gointa has her own Sridhan, gold, silver, so and so in lieu of landed property, ensuring annual payments of gifts on different occasions towards her share of father's property as per the marriage gift and all these things prepared at the time of marriage, landed property so and so, gifted to her so and so. And and importantly, that after annexure 8 plots, use points from this set that describes landed properties. She has some kind of income from that landed properties. And let's turn to page 158 also.
Yes.
She is not a dependent, absolutely no income at all. That's not the case,
See, the distinction I am trying to tell you is she may not have any income and she has been made as a co-accused. No problem. Everything has to be explained by her husband. If she put forth her own stand saying that these are the incomes, I have independent income or something of that sort, then he has to face the trial and explain it. If she says that everything is my husband's property, then husband is the principal accused. He has to explain. See, the part of avertment goes. You would examine that in that light.
I've gone through it, my lords. In fact, if lordship turn to page 158, one last case. 158, 158.
Yes. Yes. Yes.
So, my lords, in the name of petitioner, the ill-gotten money was stacked in the name of the petitioner.
Maybe.
That's the factum of abatement, my lords. Any person who receive. That's in the.
Then see my judgment. I have distinguished that.
In that judgment, my lord, the Lanama judgment and the recent judgment of S. Santi judgment was not placed before lordship. Because in
the judgment is upheld by Supreme Court. The one which I passed.
Then I must congratulate lordship. But at the same time, my lord, in the meantime, my lords, on the basis of this.
It may be in the name of husband, a wife. No problem. If the wife comes out and says that, I have acquired this property through my own income, or my mother has given, or my father has given and all, then she has to explain. If it is purchased by the husband in the name of wife can't be an abator because the fiduciary relations. That's the difference.
That's another aspect. Lordship can't talk about this one.
One thing.
1 minute. This is a legal issue only. Nothing to on fact. Clean distinction has to be understood.
Lordship, turn to paragraph 8, my lords. Lordship got it, my lords?
Yes.
This is that latest judgment of Supreme Court, Santi, that came up the lively law. Here, the same ratio laid down by the earlier co-equal bench also was rejected, my lords, to the extent, what is the law? That is the Nalama judgments. Lords, you can see what is the law laid down in that. Lords, you turn to para 25, my lord. In the same para 8, the last paragraph.
Yes.
There are certain
illustration. Such illustration you are talking.
Yes, my lordship. Such illustration are, you also turn to the previous one. If a public servant is a close friend of his, that he has acquired considerable wealth, but he can't keep it as he has no source of income to account. He requests A to keep the, you also can see the game passes and in
the name of A,
to keep the said wealth in A's name and A accepts or obliges the property servant in doing so, if it is proved petitioner A is guilty of abatement of falling under the.
You are right, sir. That's what I'm saying.
Yes, get
A I can understand. If the A happens to be the wife, the fiduciary relationship come. That is the reason I have written in that judgment. Just to go through that judgment, where I said that the wife is financially and otherwise dependent of the husband. If husband gets the money and he this is a common practice in Indian this thing, and wife doesn't question the husband. Some property is purchased, come and sign it. They go and sign it. They have no say on that.
Well, this is
but that is not abatement.
But this
abatement is, see, try to appreciate abatement. The thin distinction is abatement is before commission of crime. What happens is husband gets some money and purchase some property, tells the wife, "Chala tomare mu property ta kar devi." That lady had no option. She goes and signs wherever the husband says. Whether it is abatement, therefore I distinguish it. Unless the wife, after the charge sheet is filed, she comes and try to justify the income of the husband. If the moment she justifies the income of the husband, then she is a part of the conspiracy, part of the abatement. She has to face the trial and justify that in the trial. If she says that I have nothing to, I don't have any income, everything is my husband's income, then husband is to explain. That's the distinction. You are reading this A. A means it indicates A. It is Benami. Benami. If government servant purchases, get the ill-gotten money, use that money in the name of A.
With the consent.
With the consent. Maybe with the consent. Then it is Benami transaction. But when it comes to A, if A happens to be wife, since there is a fiduciary relationship, you have to analyze that.
It is one part of the coin, my lords. Other part of the coin is, in most of the cases, my lord, they sail at the same boats. They have the united mind.
Maybe same.
That cannot be.
Unless the wife comes forward and try to justify the income of the husband, she is not an abatement. That is the distinction.
So I'll bring that. So no.
You just in that light, you just.
I'll
just keep it. Keep it in some other
look it. But if a lot permits one thing, my lord.
Yes.
Mr. Mahapatra happens to be was the senior standing counsel vigilance. I will learn many things from him. But the earlier bench, the previous bench, my lords, he has raised only the entire controversy was in one point. That in this case, my lord, the unique thing happens. Mr. Mahapatra indicates that the sanction order was issued earlier, but subsequently it is reviewed.
Sanction.
That's ground he has taken.
19.3 will not help him. Sanction will not.
I agree, my lord.
That's a very weak point.
Because the last
very weak.
The point I've raised that.
Just ignore that point because 19.3 clause A will knock you out. But the distinction which I said, you please examine in that light.
Yes.
And Mr. Das will also examine.
Point you should look into it. This particular property has been purchased by the husband. As per the conduct rule of the husband, he has obtained prior permission. And in the letter,
I will not go into merits of the case unless you only this thin distinction you show me in the record. I'll simply quash.
Show me
that part only. That is the only defense you have.
I see. I see which part, madam?
What you have to simply say that the properties which are part of the ill-gotten money, it may be in your name, no problem. Whether you try to justify your husband's this thing, is it the case of the prosecution? If you justify, then you go and face the trial and justify it in the trial.
At page 162, my 227 5 rights.
Once you start justifying your husband's ill-gotten money, you have to face the trial and sail in the same boat.
In the 161 statement, my husband stated that he has purchased a property in my name. In my 161 statement, I have stated that some property has been purchased by my husband. In 227 petition, I have said my husband has purchased certain property in my name.
So these are the disputed facts to be sorted out in the trial only.
It's a defense play.
There you are having the problem.
But regarding the abatement, my lord, the entire charge sheet indicates
That's a very thin aspect. That's
very thin line. very silver line. You have
Yes.
to understand where
Agreed,
you stand.
agreed, my lords.
The moment you try to
This is
justify your husband's,
This is a plea taken by everyone.
then you have to face the trial and
I don't justify my husband.
any property in the least, if you are trying to justify that, you have to face the trial and
No, I don't justify any property except only one property.
then for that property also you have to face the trial.
I don't justify it. I don't say that it is from my own income. My husband with prior permission.
So that is what if you simply say my husband has purchased it in my name,
Yes.
then no problem. The husband has to explain that.
I have got that document with that permission has been granted. There was what he has revealed. I want to purchase this land from this vendor. This is the area of the land. This is the valuation of the land. I will purchase from this particular vendor and purchase in the name of my wife, and the money is from my GPF account. He has given prior permission.
Then the husband has to explain that. Wife has nothing to do with it.
So I have nothing to do. He has purchased. He has obtained prior permission. He has obtained it.
Don't try to justify your husband's income, then you are out. Mr. Das, you just see that thing like and tell me. Then he will be out. He will be out.
But at the same time, my lords, I'll just go to my lord. Since the last bench has passed an order, judicial orders, I have to apprise to your lordship that particular plea my learned friend has taken, my lord. My lord, that I'll answer, my lord. But I'm not taking time.
We'll see that.
That
First, you read that
page 15, your lordship.
We'll see that sanction I am not. Sanction I am not agreeing with.
May take back that
sanction. You don't have a case.
May take back that judgment.
Sanction why your husband? Why are you getting into all this thing?
But at the same time, this plea is available to everybody. I'm penniless, I'm dependent, these things, please, are being taken in almost all cases. But this is a conspiracy in secrecy. And in fact, they act in tandem roads in most of the cases.
But that can't be an
exception. I agree with the lordship that
in the Indian context, you have to think.
In that sense, Sonata Mata is saying, I have no income at all. No possession.
The moment he says that I have no income, it is husband who has to explain it. He has to face the trial and explain what the wife will do.
In that proposition, the factum of giving or accepting, offering or accepting the offer that mutonarti rakhuchi. So that is available, not available.
Practical situation dekhuntu na.
I'll come back to lordship.
Husband comes to get some money somewhere. He says that tomar property kurchi chala property sign kariyo. Gola che sign gola. তাহলে এবেটমেন্ট না যদি সাইন কলা পরে সে যদি আইকি জাস্টিফাই করছন্তি নাই মো হাজবেন্ড এমপি আনতে he has to go and face the trial. If she simply says that I don't know, my husband told me to sign the paper, I signed the paper. Then is it an abatement? Why should she face the trial?
I will examine that one, but in most of the cases, the better halves always add fuel to the fats.
It's not in Indian context.
And the entire charge sheet reveals only one particular line, single line.
I will examine it. We'll not further. We'll examine. Illicit. You tell me, Mr. Das. Now ball is in your court now.
Today is 27th.
Let it be on 17th of August. 17th August. Huh? And with that judgment, just see and compare it. Yes.
That final aspect, your lordship to explain that.
Yes.
Amplify that one.
Yes. You read that my judgment. There I have explained in two paragraphs. I don't know.
Which got the endorsement on the Supreme Court. Sonalata.
I think so. I think so, but 2-3 paragraphs I dealt with this kind of fiduciary relation.
What deploying has a punitive relation with the husband.
Just see. Yes.
Beg pardon, but I don't feel after stay realization that
Yes, next.
Item 16.
May I submit one thing? Let go after lunch. I'll just
this one
after lunch.
I'll put it some other day. Then let it be on 3rd of August. 3rd of August. Okay.
I beg your pardon, I told not 15. Your lordship has adjourned to 17th August. I have no problem. But trial may continue.
Continue, nothing will happen. If you are out, you are out. Yes, even evidence is recorded, you will be out. No problem.
That was only.
I see. Don't worry about it. Yes. 17.
But they are,
Please, my lord. My lord,
they are, all- if Lordship, sorry. They are also finally examining Lords. Once the trial begins after framing of
I
charge,
will see on
either it has two consequences, either it will be acquittal or conviction. No question of discharge in the midst of the trial.
we'll see that also I know. We'll see that.
Your my petition has been filed the day after the discharge.
We'll see, sir.
Dismissed.
Wait till 17. Wait till 17th, we'll see. Okay.
May I please, my lord?
Yes.
My lord, petitioner is a esteemed member of our bar association, my lord. He is having a gun license since 2010, my lord. Kindly have a glance to Annexure 1, my lord.
What are you challenging?
Yes, my lord. Page 19, my lord.
A renewal of gun.
Non-renewal, my lord. Because, my lord, there is
You are a lawyer, what will you do with the gun?
his father's gun, my lord, transferred.
Okay.
That is an asset of his father, my lord.
I'll just simply issue notice. Let us.
Yes.
Get,
One, that direction may be given to the collector to dispose of that Annexure 2, my lord.
No, I don't believe
Then, my
that.
lord,
Representation business.
Yes, my lord, I'm obliged.
Get the, if you deserve, I'll allow it. Simple. Yes.
My lord, no entry, no coercive, my lord.
What coercive? They'll take the gun and fire somewhere else. What coercive you have about?
Then, my lord, it's all right. I'm taking
You don't need a license. You'll get the license. You want to use it in between.
No, even he had not purchased.
Are you interested to use it in between?
No.
Then
Even he had not purchased.
better you
the
concentrate
cartridge,
in
my lord.
practice. Better you concentrate in
My
practice.
lord.
Don't use the gun.
I'm taking notice, my lord.
Yes. Next.
Motivation, brother. Item 18.
Yeah, what modification?
Recording of order. Recording of order. 18. Item 18.
Which order is recalling? TC order. This is just house order. Yes. You are appearing?
petition order. Dispose of it.
This is for what?
But the session judge the letter received from the district and session judge. Sorry. It is 919.
What is this? 138. Can I?
Item
Go on
18.
to them.
Recording of order 23.
2016.
On what ground? I number?
I number 2485 of 16. Flexi.
What is he seeking? The option of the petitioner. This is 138 case. Main ground of is that the complainant has received the entire check amount and food when the filed an application is shown super petition the grounds have been taken from the so now or proceeding quashing. By order dated 23/8/2016, the criminal MC number 2228 of 2012 was disposed of inter alia recording agent. Since the sole ground, the paragraph of ground. The counsel for the petitioner has moved but on 7/10/2016 has moved the present application seeking recall of the order dated 23/8/2016 on various grounds. When the matter is taken up for hearing, none has appeared for the petitioner. Moreover, I have perused the grounds taken in the application seeking recall of the order dated 23/8/2026. I'm not satisfied with the grounds urged by the petitioner. Therefore, on the ground of non-prosecution, I will on the same stands dismissed. Yes, next. Dismissed. Yes, next. Item 19. Yes.
Letter from a DC from the district.
What is this? Letter from 2014 letter. Why it is listed now?
Letter has been received from the
Letter received from
SDGM.
DCGM currently seen. Letter from SDGM Nagar is Flag C, huh? Flag C. Flag C. What is letter with reference to the letters of the after tracing out the original record here from split type of record so with respect to rest of the two is representing from disclose upon so hence I'm subject to the compliance. There is a disclosure of the mentions split up the letter dated 6/2/2014 issued by SDGM Niagara is the cause of listing the matter before the court. The letter reads as taking note of the contents of the letter, the petition, the matter is closed. Yes. He said that after splitting up, we have concluded the trial. Yes, next. Nothing survives. This matter. Yes, next. Item 20. Yes. What is this? About the event. Clarification of the order dated?
41/2015.
Which order you said? 14/1/2015. Kindly make extend surrender before the right of wide order dated 14/1/2015.
Extension of
The
the
petitioner was granted 2 weeks time to surrender before the court. Surrender before the learned SDGM Dhenkanal in GR case number 865 of 2013. 13, with that condition, the NBW issued by the said court, wide order dated 1/11/2013 was cancelled. By way of the present application, the petitioner is seeking extension of time. At the belated stage, this application cannot be entertained, hence the same is dismissed. Yes. 21. Yes, 21. What is this?
For extension of time.
Huh?
Extension of time.
Extension of time. Extension of time. Where is that order? Extension.
Plan B.
The NBW order issued by the NBW order dated the order JMFC Patamulai issued non-billable warrant against the petitioner by order dated 15/9/2014, which was challenged by the petitioner by filing CRLMC number 67 of 2016. By order dated 29/2/2016, the NBW was cancelled subject to the petitioner surrenders before the court for JMFC within a period of 3 years. The present application is moved for extension of time. At the belated stage, such application is devoid of cannot be entertained, being devoid of merit, and the same is dismissed. Yes. 22. Yes. What is this?
The opposite party.
What is this?
Finally missing a letter.
Right on. By the order dated 16/6/2016, the designated court OPID issued NVW against the petitioners, which was challenged before this court by filing PRLMC number 1909 up to 2016. This court, by order dated 22/7/2016, directed the petitioners to surrender before the learned special court, designated court OPID, Barampur, in GR case number 5959 of 2012, on or before 8th August 2016. It appears the appellants have not surrendered before the court and moved an application for extension of time. The extension of time on 7/2/2018. At the appellate stage, the such application cannot be entertained, being devoid of merit, the same is dismissed. Yes.
My name is
Dismissed. Yes, next.
24.
What is this? Extension.
Flag B. Appropriate of use.
Flag
B.
B. Yeah, B. Appropriate direction. Required. The autumn should be not required to enter the required since for the petitioner. For petition inquiry, regard to the this application is earlier the petitioner had moved this court seeking quashing of the FIR, which was turned down by this court by order dated 19/12/2017. By way of the present application, the petitioner is seeking additional direction to the investigating officer to conclude the investigation in respect of Barampur Vigilance FIR case number 45 of 2016, corresponding to GR case number 33 of 2016. The application is devoid of merit and the same is dismissed. Yes.
25.
Item 25, my lord. No case record has been transferred to CJM Fullband, my lord. Therefore, I have filed.
What are you seeking, sir?
My lord,
What are you seeking?
I filed a miscase for modification of order, my lord.
Modification to the extent? See, the order was passed in 2018.
My lord.
And today you are passing, moving an application that I'll surrender some other.
Immediately file करते हैं अपना आसी नफला केस पर बर्तमान पेंडिंग अच्छी केस टाइम
You have not surrendered.
आपियर को ने ये तो बालीगुड़ा पे ऑर्डर रहते ला मैं उसके आपियर को रिपेयर नो एसडीजीएम बालीगुड़ा वाले डायरेक्शन रहते ला सरेंडर करियो
By the order dated 16/3/2017. The learned court of SDJ Baliguda issued NVW against the petitioner in relation to GR case number 148 of 2013, which was challenged by the petitioner by filing CRLMC number 1339 of 2017. This court, by the order dated 9/1/2018, directed the petitioner to surrender before SDJM Baliguda, and move for bail application. Till then, the execution of the NBW was kept in abeyance. The petitioner, by the present application dated 19/1/2018, seeks a clarification or modification to the extent that the court has already been changed. Instead of SDJM Balikuda, a direction may be issued to the petitioner to surrender before learned CJM Pulwani. CJM Pulwani, isn't it?
My lord, CJM Pulwani.
CJM Pulwani. Balikuda to Pulwani.
Again, Ballywood Pulwani transfer.
Since the trial of the case has already been transferred to Pulwani Court, CJM Pulwani Court. Pulwani Court. It appears the application is bona fide. Since the application was moved, although the application was moved on 19/1/2018, but the same was not listed before this court. Hence the delay. For the reasons stated in the application, the same is allowed. And the order dated 9/1/2018 stands modified to the extent that the petitioner is directed to surrender before the court of CJM Pulwani in regard to GR case number 148 of 2013 on or before 10th of August 2026. Since although the application was moved on 19/1/2018, it appears the petitioner has not made any attempt to get the application listed because he was in an advantage position and enjoys the direction of non-execution of therefore, he is liable to pay cost of rupees 10,000 to be deposited with the Pulwani Bar Association. Pulwani Bar Welfare Friend of Pulwani Bar Association will give 10,000. Let him go to, since you are going to Pulwani, he is had to pay to the lawyer as well as association. 10,000. 2018 you moved the application because it is in your favor, you kept slipped. Otherwise you will come every day with BMO. Because you are in advantage position, aram se question. 10,000. You show me that you have moved any memo, you mention it. You might not have mentioned. Why will you mention? So therefore 10,000 is very less. Yes. Okay.
26.
Yes, next. 26, what is this?
Extension of time.
Extension of time. 2019? Order. Huh?
19 order.
2/8/19 of time. Which order is that?
2019. 2019 order.
2/8/2019. Okay. Initial order was passed. Initially, on 26/11/2018, the petitioner was directed to surrender before the trial court within a period of 4 weeks. Within 4 weeks. He moved repeated applications seeking extension of time. It was allowed on, firstly, it was allowed on 31/1/2019. In IA number 204 of 2019, and then on 2/8/2019 in IA number 1472 of 2019. This is the third application making the similar prayer. For the reasons stated in the application, the same seems to be devoid of merit, hence the same is dismissed. Petition is the trial court is directed to issue appropriate process against the petitioner. Yes. Next. Dismiss.
27.
Exposure case. Extension of time.
Which extension, madam? Which order? Huh? You are directed to surrender within a period of 4 weeks from today. When have you moved the application? This order was passed December. You moved the application. I don't know. By the order dated 2/12/2019, the petitioner was asked to surrender before the court, before the trial court, within a period of 4 weeks. 4 weeks. 4 weeks. While disposing of the CRLMC number 1933 of 2019, the petitioner was directed to surrender before the trial court within a period of 4 weeks. The petitioner on 25/1/2020 moved the application seeking extension of time for 2 weeks. 2 weeks to surrender. The application remained pending till today. It appears that no efforts were made by the petitioner to get the application listed. Since only 2 weeks time was sought for, the extension of 2 weeks time was sought for, and that has already been left. No order is required in pass. Hence, the same is dismissed. You sought for 2 weeks time in 2020. We are 26. Again, you need 2 weeks. Dismiss. Yes.
28.
You surrendered. You instead of 2 weeks, you have enjoyed 6 years. Go and surrender now. Yes. It is open for the trial court to issue in the event the petitioner does not surrender. It is open for the trial court to issue appropriate process against the petitioner. Yes.
28.
Yes. What is this?
Petition of order 18/3/20.
18/3/20. Modification. What modification regarding circumcision? Advice so 3 weeks. Flag?
Extend the time for 6 weeks.
Right on. By the order dated, while disposing of the CRLMC number 858 of 2020, 20, this court by the order dated 18/3/2020 directed the petitioner to surrender before the CJM come Assistant Session Judge both in 2B CC number 86 of 2005 within a period of 3 weeks. Instead of surrendering as per the direction of this court, the petitioner moved petitioner on 12/6/2020 moved an application seeking extension of time to surrender. Extension of time for a period of 6 weeks to surrender. The application remained pending for about 6 years. Therefore, the prayer made the said application become infractious. Hence, the application rejected. It is open for the trial court. In the event the petitioner has not surrendered before the court as yet, it is open for the trial court to issue appropriate process forthwith. With this observation, application disposed of. Yes, next.
29.
What applications are there? Yes, next. What is this?
The extension of
Same extension of time. Right on.
Flag 8.
Right on. The SDGM Sambalpur, by order dated 5/4/2013, issued NBW against the petitioner in connection with the case, in connection with the CT case number 1736 of 2010, which was challenged by the petitioner by filing CRLMC number 875 of 2020. Also, wide this court wide order dated 20th March 2020 allowed the application directing the petitioner to surrender before the learned court, trial court within a period of 3 weeks, within a period of 3 weeks. Instead of complying the order and surrendering before the court, the petitioner on 24/1/2021 moved the application seeking extension of time. Extension of time. The application remained pending for more than 5 years. Therefore, the prayer made in the application to become infructuous. Hence, the same is dismissed. It is open for the trial court to issue, in the event the petitioner has not surrendered as yet, pursuant to the order dated 20th March 2020, it is open for the trial court to issue appropriate process forthwith with this observation petition. It is for yes. Next.
Item 30. I got this. 2021 will not.
Good. Mr. Ponda, counsel, doesn't place the application, hence the same is dismissed. Not placed. Yes. Yes.
31.
Yes. Yes. What is this? What is the application? Which application?
Let's see.
Let's see.
Let's see.
Court of Learned JMFC, Pomna District,
Liberty or security or protection for filing discharge petitions. Right. The coordinated bench of this court rejected the prayer made by the petitioner seeking quashing of the CT case number 526 of 2013 pending in the court of JMFC Nuapada corresponding to PS case number 186 of 2013. Kumna PS. Kumna PS. The petitioner has moved the present application seeking modification to the extent that seeking modification of the said order to the extent that he may be granted liberty for filing discharge application. The present application being is pending since 10th May 2023. I am not persuaded by the grounds taken in the said application. Hence, the same is dismissed. Yes.
32.
Yes. What is this? What is this?
Flat email.
K. K. Yeah, K. Modification of the order dated 6/2/2024 and 31/7/2024. So under chapter so for so what modification he needs. Also to modify the order and may be recalled and prayer made by the petitioner may be allowed after hearing party. Petitioner क्या prayer किया था? Please, sir. So, Right. Petitioner, by filing CRLMC number 3126 sub 2023, challenge the order dated 22/3/2023, by which is the application under section 239 CRPC seeking discharge has been turned down by the trial court, and the charge was framed against him. Charge was framed against him. The said application was subsequently listed. The CRLMC was subsequently listed before the court on many other occasions, and eventually it was dismissed. By way of the present application, the petitioner is seeking modification of those orders. The ground taken in the application is not persuasive to accede to the prayer made by the petitioner, hence the same is done now. Yes.
33. My lord, in this case, I was directed to surrender by 30th March of 20.
Which order?
My lord,
Which order? The order dated?
order dated 22 to 24.
When have you moved the application now? 24. Now we are 26. How much will you pay?
My lord, in between the lower court has issued one summon to the accused dated 17/3/26 and to appear in that particular day.
Then you appear, go and appear.
Extension.
When the date is fixed now?
17/3/26 issued and to appear on 17/3/26.
No, by the order dated, by the order dated 28/2/2024, this court directed the petitioner to surrender before the court, surrender before the learned JMFC CBI in GR case number 408 of 2015, within a period of on or before 30th of March 2024, and the NBW issued against him by the order dated 10/3/2023 was kept in abeyance. Instead of surrendering before the court as per the direction of this court dated 20/2/2024, the petitioner has moved this application on 15/7/2026. This is 26.
17/3/26. Someone was.
No, I'm talking about the application date. What is the application?
15/7/26.
15/7/2026, seeking the extension of time. The application has been apparently moved belatedly. Learned counsel for the petitioner submits that in the meantime, the court below has issued summons to the petitioner on
17/3/26.
17/3/2026, directing him to appear before court on
17/3/26 itself.
On the same day. Same day. Hence, he submits that his time may be extended so that he can the petitioner can surrender before the court as per the direction of this court dated 20/2/2024. Regarding it to the submission made by the petitioner, I'm inclined to allow the application directing the petitioner to surrender before the court on or before 7th of August, 7th of August, so and so, subject to the petitioner depositing 5,000 rupees as a cost. Before which court you surrender?
JMFC Chandwali.
Chandwali, the Bar Association Chandwali. Yes. You know, yes.
34.
Extension time lordship. Order passed on 22/4/26 lordship. Targeted 15/5/26 दिया surrender ପାଇଁ lordship.
Surrender by
15/5/26
right. While declining
lordship
application
on the date
for
of the hearing,
grant of
the conduct are not present
this court by order dated 22/4/2026 directed the petitioner to surrender before the court on 15/5/2026. However, for the reasons stated in the application, the petitioner submits that he could not surrender in time.
STM has
Seek
no power
extension of
to release the bill.
time. How much? How much time? 10th. He submits that time till 10th of August may be granted.
Lordship, STM no power to release on 307 lordship.
I don't know all these things. You surrendered, I'm giving you time. 10th of August. 10th of August. Okay. It's made clear that no further extensions are being granted. Yes.
Faster thing.
Yes. Next.
35.
Malad in 35 9
Yes.
Malad here, in fact, the warrant was under challenge. Initially, this will be put on the premises that I am already on bail, granted me bail. Later on, it was found that in fact, there was a transit bail, and after I didn't appear, warrant was issued. So a recall application was filed, order was recalled, your lordship. At our VS recall application was filed because of the fact that on a mistaken premises, the relief was granted. Now, madam, the main case is there.
What are you challenging? 4/4 order. What is it? 4/4/2014 order you are challenging.
Yes, ma'am.
4/4/2014. Let us see what is that order is about. Accused Sukhdev files Hajira, advocate Manti and associate files so on behalf of Lakshminder Sahu along with petitioner with so on so. A prayer for bail. Copy serve. God is but accused by the home sitting that he does not want to press the petition. Hence the petition is rejected. The accused is absent. Because NBW has been issued against you.
My lord, co-accused has been released on bail. I have indicated NBW has been issued, but the present status is not known to me.
But only NBW has been issued against you. That's what you are agreeing. Don't surrender.
But your lordship may kindly see paragraph 8, page 4 of the application.
Paragraph
8, page 4 of the application.
4 of your application.
Yes, ma'am.
What do you say? Paragraph 8.
Ma'am.
Relevant to state that the co-accused Sukhdev Kalra has been released on bail by this court on social. Oh, it's all right. Go and surrender, move for bail application. Pay some money.
Saying that in view of the fact that the co-accused.
Oh, it's all right. Right. Petitioner is agreed by the order dated 4/4/2014, whereby his application what was that application you moved?
May I just clarify what happens normally in trial court?
Application. 1 minute. Application seeking grant of bail was disposed of being not pressed, and at the same time, NBW against him was issued. LBW against one issued. Drawing the attention of this court to para 8 of his petition, he submits that the co-accused Sukhdev Kalta has already been enlarged on bail by the learned Sessions Judge Judge Special Court Sambalpur by the order dated 3/6/2030.
I was also granted
Learned Senior
transfer.
Counsel submits that the NBW has not yet been executed. And on instruction, he undertakes to the court that his client would appear before the court, surrender before the court on or before 10th of August 2026 without pay. Since the petitioner has been successfully avoiding the process of the court, and at the same time, the state has also failed to execute the NBW issued way back in 2014. The petitioner shall pay a cost of rupees 10,000 before the Sambalpur. It is Sambalpur. Sambalpur. Sambalpur welfare cost. It made clear that no further return shall be granted. 10th of August, use surrender and move application. Liberty is granted to the petitioner. Move appropriate application seeking grant of bail. Yes. Appear 10th August.
The co-accused on bail, man.
I have recorded that co-accused has already been granted bail. You move application there. This is not a bail application.
True it is, man. There is a warrant in place, man.
I have recorded that. You can get the parity. Okay. Yes.
That much your lordship may indicate, man.
Yes. Yes.
Thank
Next.
37.
That's
Permitted to withdraw, file a better application. Permitted to withdraw, file a better application.
Counsel for the petition seeks to withdraw this. This is an application or main petition?
Main petition, lordship.
Petition. If you withdraw to file labor petition, better particulars and documents. Yes. Next.
38.
Yes.
38.
What is it? This matter. So, what is this matter, Jibo? Passing of the entire proceeding. Is there any stay, anything? Non-appeals for the petitioner in the interest of justice. September. September. By the time investigation would be over. Yes.
39.
My lords, appearing virtually in this matter, the petitioner in the matter has been settled between the parties, my lords, on 8th November 2024. It has been approximately.
This is the sufficient.
It is approximately 2 years, my lord, that the matter has not been quashed even after the matter has been settled between the parties. The opposite number 2 confirmed and agreed to withdraw the matter after the settlement. But he
where is this terms of settlement?
My lords, it has been filed and it is. I have filed it, my lords. A settlement agreement has been filed. If my lords may see the records. 8th November 2024, my lords. It has already been filed before the court.
Service is complete. He is not coming.
No, my lords. On 8th November 2024, the settlement took place. 30 lakh rupees was given to opposite party number 2 by the petitioner.
Show me that you have paid proof of payment.
My lords, I have furnished the proof of payment along with the.
Show me in the record. Show me where have you furnished. Show me.
My lords, it's there. I have filed it before, my lords.
It is there, means where? Show me. It is a big petition. Which page? Which page?
No, my lord. It is filed through a memo.
You come tomorrow. You
My
come
lords,
tomorrow
I am
here.
not- I am
Come
not
here tomorrow.
Okay,
Come
my
here
lord.
tomorrow. I'll dispose it at tomorrow. Come here and show me where is your. Yes, next tomorrow.
Much obliged, my lords.
Item 40.
Item 40, my lord, I played a small Passover.
They already settled. My money is paid. I'll dispose it of it. There is nothing. Payment has already been made. Yes. Good. Letter come. Because see, money is paid. Service is after taking money, he is not coming. Why should the court will be burdened if he can show the proof? Letter come. They should face the court. Huh? It's all right. Day after tomorrow. Day after. Okay. Day after. Yes.
Item 40.
40, I pray for a small Passover. He is on legs in another courtroom, my lord, and
What is this matter, Sibo?
my lord, it's about portion of the the state was supposed to take instructions and the IO had appeared to VC in the last day.
It was adjourned to 21/8/26.
My lord, we had filed an IA
in
for,
that case-
it was inadvertently adjourned to 21st August, my lord.
What is the great urgency? Let it be on 21st.
Well, urgencies can be disposed of, say.
It can be disposed. Every matter has to be disposed of today or tomorrow.
Oh,
That can't be an urgency.
my lord,
Let it be on 21st.
My lord,
By that time, they'll
that's
get things.
different. I just pray for a small Passover. Just a small Passover. He is on legs in another courtroom, my lord. The urgency is there, my lord.
Even after Passover, I'll do the same thing. Okay, no problem. But I'll pass over.
Well, the order was dictated to be adjourned to 21st.
It's all right.
July.
Now, what is the great prejudice? The investigation is still going on, it seems.
Well,
Isn't it?
That case under waiting
Yes.
final.
Final
So let us
report was-
understand,
That's
give
why
sufficient time if you may be, dropped also. That is what they made a statement.
That is what they means.
You make a hurry, they'll file a charge sheet against you. If you want that, I will do it.
All I request is.
I remember I called the
My lord, my lord. My lord.
I know he made a statement
He made a
that
statement.
we are likely to file a closure report.
Closure report, my lord.
If you pressurize like this, he'll put on file a charge sheet and keep on fighting.
No, my lord, no. I don't. My
Give
intention is not
space
that.
to
My
the
lord.
investigating agency also.
It is not my.
Okay, I'll pass it over.
My- Obliged.
Yes. Yes.
Item 41.
May I please, your lordship?
Yes, madam.
My lord, the present appellant is languishing inside custody since 2014, my lord. Nearly more than 11 years, my lord. And he is granted 4 times interim bail and never meets
You
utilized.
have the custody certificate with you, Mr. Das? And I think in all the matters where you don't have the custody certificate, jail conduct and antecedent, these 3 things you get it.
Okay.
Today's matter, I'll put it next week. You
Yes,
get
sir.
it, we
Yes, sir.
consider 11 years already undergone. That's the sentence?
My lord,
20 years.
20 years. 20 years.
Okay.
More than 11 years is in 4 times interim bail and surrender certificate.
Get the jail conduct and all, huh? 3. All the 3. Custody, jail conduct, and antecedent. Please the matter after 10 days. Cyril does. Cyril the other king. 2016 matter. Cyril the date. Okay. Okay. We'll see how we'll adjust it. Huh?
Yes.
Okay. Yes.
Item 42.
Yes. Yes, sir.
Lordship, for the petitioner, my senior is not available today. I pray for an adjournment.
You want an adjournment? What's the custody period?
Custody because
Custody certificate is there.
it's almost 8 years, Your Worship, because in 9/5/25,
Yes.
7 years, 11 months is the period undergone at the time. So 1 year, 11, 8 years, 9 years of
What is the sentence?
sentence 20 years, Your Worship. 376D, Your Worship.
Okay, you get the jail conduct and antecedent. Jail conduct and
Your Lordship, may I pray for
Ma'am.
a copy of the plaint and trial court record because the documents have been.
you can
dismissed.
take it, ma'am. Soft copy you can take it. Huh? Yes.
Okay.
Next.
43.
All the time. Yes. Yes. 43.
May I please, Lordship?
Perhaps this is the internal communication for this Honorable Court and the learned court below. They have prayed for some order. Disposal. The court below prayed before your lordship for disposal of the ganja packets. We have no objections.
Have you seen the report? Have you seen the report? Mr. Rai?
No, they have not soft copy.
You come and see the report, soft copy.
As your lordship, please.
Come and see the report. There is a report filed by the learned deceased Judge Kurda on 4/7/2026. That's why the that's why the matter is listed. Learned counsel appealing for the petitioner submits appellant submits that he has no privy to the said document, short document, and he seeks time. It's time to go through the report. Please the matter to day after tomorrow. Day after tomorrow. You just read it and tell me day after tomorrow. You come and the soft copy you can read and immediately.
Yes, yours.
Yes.
45.
Third copy. Third. Yeah, third. Yes. Yes.
Let's say item 45 can be taken up next week.
Sorry?
Can be taken up next week. Let's say item 45 at least miss out from the list. We have not.
What is this matter about? This is for bail or what? Why for this matter it come now? Bail.
State to produce.
Same thing. All the three. Yes.
46.
Obligation. Please, Your Lordship, the district and session judges filed for filed a letter, my lords.
Sorry?
Item 46. The letter filed by the district judge Kurda, my lords. Letter number at flag C.
Flag C.
For disposal there.
What is this report is?
They made a prayer for
Have you gone through?
They paid for a disposal of the 33 packets of ganja, my lords.
Thus, the opposite decision permission is required from the honorable court for disposal of the 33 bastas. Yes, what do you say? Have you read the report? Read the report. Third. You read the report and suggest. There is a report from district judge. Appeal is pending here.
Yes, sir.
And the ganja are lying there. What to do? You just tell me. Assist me. Because the other matter is also like that.
Yes, sir.
Both the matters you read and tell me what order should be passed. Yes, next.
47.
I am appealing for appellant number 4, my lord. My NOC, my booklet is kindly accepted, my lord. And file booklet in consent of the my lord.
You are for appellant number 4.
My lord.
Manoj Kumar Sahu.
Yes, my lord.
What about the other you are appealing?
For 3 years.
I am for appellant 1, 2.
And for 2?
1, 2.
1, 2. Yes.
My lord, I am number 1480/26 my lord. For bail, my lord. I am in custody, my lord. Who will be the
Let me ask. Only this application is there. Your application, or you have also?
I have surrendered here also,
Huh?
and I will file my surrender, sir. And I have not moved for any question.
What about you?
I have filed today. I have filed.
You do one thing. You get to the custody period of all the 4, and conduct and all.
20 years punishment, your lordship. Sentence is 20 years. More than 11, 12 years has passed.
So therefore, let us see. Thereafter, I will exercise that leti and will start moving. Okay.
for me to file my lord custody certificate, my lord.
Officially let him get all of the, Yes. Now we'll fix a date. We'll see and fix a date. Making it for you. Yes. Yes, next.
A short date candidate. Super Anivina.
Yes.
48 May, please.
Yes.
Sorry. Let's the lordship may have a glance to last order, my lords.
But you have raised an issue whether he should have been tried in 2008 or 2015 Act.
My lords, because your lordship may just record two dates, date of birth of appellant.
Yes, Mr. Das.
Yes, Your Lordship.
He raised a point. He should have been tried under 2000 Act, not 2015 Act. And the State Council had taken time to address the court. I think this thereafter the first time it's coming.
Yes, this has been spicy.
The court has changed, the prosecutor has changed.
Yes. Because my lord.
What do you want? Select.
Yes.
Let him prepare.
My lords, just one thing, if I don't need the matter, my lords, this matter was specifically listed on 24th, my lords, because my extension of time to surrender would expire on 24th, and the same could not be listed on 24th, so I have filed an extension of time to surrender. Also, I just have a last to second last order. I have been granted interim bail, my lords, and that was extended. And when the court was satisfied that
when interim bail was granted to you?
My lords, I was granted with interim bail
For 2 months.
my lords. 25/6 to 2026. Thereafter, my lords, the said
25? 25?
25/6, my lords.
25/6, okay. You have been granted 2 weeks.
No, my lords. 25/6 it was extended. My lords, 17/4 I was granted 2 months.
Initially.
My lords. And the matter was supposed to be listed on 20.
Yes. What do you say? I'll extend it once again.
Yes, sir.
By the time you read it. Okay, right.
Lords, may I just-
By the order read it. Yes. What do you want?
May I just pray that my second prayer may be considered till disposal of the my lords.
Wait, I'll dispose of next date of hearing. Don't worry, he will let him prepare. Right, by order dated 17/4/2026, the petitioner was granted interim bail for 2 weeks. 2 weeks initially. 2 weeks initially granted.
2 months.
2 months. And subsequently, by order dated 25/6/2026, it was extended for another period of 2 months. Isn't it?
No, my lords. Till 24th July.
Till 24th July 2026. The petitioner has moved. You have not surrendered.
No, my lords.
Why have you not surrendered?
My lords, before that I have filed for extension.
That doesn't mean that without any order you will not surrender.
Lords, there is medical issues, my lord.
You should have surrendered.
My lords, I have also filed for.
When have you moved the application?
This
When is
application?
that?
This application
Extension of time?
has been filed just after.
Yes. However, on 6/7/2026, he moved an application seeking extension of extension to for 6 weeks time to surrender. The application, unfortunately, the application could not be heard before 24th of July. 24th of July. But fact remains that the petitioner has not surrendered pursuant to the order dated pursuant to the order dated 25/6/2026. Be that as it may, for the reasons stated in the application, the time to extend surrender is extended up till 20th of August. 20th of August.
Some long time, my lords.
20th of August. Release the matter on 10th August. 10th August. For further hearing. Yes, 10th August.
So matter, I don't think this has been issued or not. To verify version.
Notice was issued or not?
Chalo.
Notice was issued? No notice was issued. No. Since one of the offences for which the appellant has been convicted is under POCSO provision, issue notice to the informant oblique the complainant. No, the notice to be served through the IIC. Which police station is that? Which police station?
Yes.
Police station? Huh?
Hon'Ble
Police station. Okay. Is the matter on 10th? Get ready with. Yes, 10th. Okay.
49. My lords, urgent. My lords, NBW would be issued. My lords, so.
NBW has been issued?
No, my lords, it would be issued. So.
We'll get it. Okay. Next.
Urgent copy in course of the day, my lords. Great, my lords.
Yes. Yes, 49. What is that? What is this? Bail. Call for the report. Call for 3 report. Calling for the report. Yes, next 50.
50. My lord, kindly have a glance at the last order.
Yes.
Conviction 10 years. Out of 10 years, I am in your custody more than 8 years. And last order on 3/7/2026.
Yes.
The appeal.
Written note of sufficient file by the General Counsel appearing for the appellant. Court on Show me the custody certificate. Show me. See, 8 years is already undergone out of 10. I'll grant bail if it is true.
Yes, sir.
Show me the custody period. Because see, this appeal is pending since 21. I don't think it can be heard within.
Sorry, hearing paper, written note, they did. So sorry.
You want the appeal to be heard, then I'll hear it. At least it in weekly list and finish them. It is your choice. You want a bail or appeal to be heard, then I'll list it on the coming week in the weekly and finish it up. Appeal to be heard?
Yes.
If you have a good case, better you argue the appeal.
Yes.
You will be a good date.
And
If you don't have a good case, take bail and go.
Then I also will add my written. I'm ready to next.
If you are confident about your case, then
Yes.
list it in weekly list next weekly. Next weekly. Get ready. What is the offense?
22.
Okay.
Compliance of the 52A and 55, 52 there in view of the evidence of the PW 15 and 16.
Then argue it and finish it up. Include.
Written note you file for the draft. Sorry.
Okay. Okay. Weekly list. Mr. Panda, Learned Counsel for appearing for the appeal submits that he would prefer to argue the appeal. Appeal instead of pressing the application for grant of bail. Hence, list the matter in the next coming weekly list for filing. Yes.
I may be pardoned, my lord. I may be pardoned, my lords. Instead of 10, my lords, 11 or 7, I have some personal difficulty, my lords. 11 or 7, any date that is convenient to
11, not 11. Let it be on 7th, huh? 7th.
7th. Grateful.
7th. 7th could be, yes. Next.
In this matter, appellant has convicted.
Which one? 51. Yes.
10 years. Out of which he has already spent 7 years in custody. Custody certificate is also there. On last occasion, this honorable court directed the state council to give that custody certificate or not?
Yes, that is there.
It is there, my lordship. In the last order, it was reflected.
Yes. Yes.
The conviction is for 10 years.
10 years. Undergone period?
7 years.
What is the age of this person?
Petitioner by 30. At the time of occurrence, the petitioner.
What is the age now?
29.
What is the age now, sir? I'm touching.
37.
36. 35.
What is the name of the accused? Name of the accused is?
Judgment is of.
What is the name?
Name of the appellant?
Appellant, yes.
Isan Pingua.
Isan.
Isan Pingua.
Isan Pingua. Isan Pingua. In 2019, he was 35.
Yes, Your Lordship.
In 40s. He is in
But
40s.
in the order itself, it was showing, in the judgment,
Oh, see the final form. Final form shows 35.
the
Yes.
judgment, it was like, he is
Judge,
30
forget about
30
it.
years.
Yes. What is the material?
His father is a old living person.
Who are the eyewitness? Show me why.
The victim is 55 years old.
At the
At
time,
the time of occurrence, my lordship, he
Who is the victim? Tell me who is the victim. PW?
PW 10.
10.
Yes.
Let us see.
There was previous enmity between the parties that has not been taken into consideration. PW9 has.
Well, the age of this girl is what?
55 and the
Lady, my
old lady.
lordship.
55 years.
Who is the doctor?
The doctor.
Yes.
PW 12.
12.
Doctor remains. No external injury was detected.
5 and 12.
Victim was there, no injury. Both the doctors report are silent.
No, my lordship, it is there.
PW 12 is the doctor. Another doctor is.
When was the incident?
Year 2019, your lordship.
Date, you tell me date, I know.
19/11/2019.
19. 20th this has happened. Right on. I will grant bail. Yeah? See, 19th this incident happens. 20th she was examined. The doctor says that there is no recent sign of any accident to post. 7 years he has already undergone out of 10. I can't hear the appeal.
For finding instance, sexual intercourse cannot be excluded.
That is but though there is no conclusive thing, you know. The appeal is of which year?
Appeal is of the year 2021.
21 appeal. Can't hear it.
Yes.
I know. Petitioner has been convicted for offense under section so by the court of so in the city case number 2. On the count of he being convicted for the offense under 376 only?
376(1).
376(1). He has been sentenced to undergo RI for 10 years?
10 years.
10 years. And what is the fine amount? What is the fine amount?
10,000.
Default to undergo so. The custody certificate produced by the state. Where is the custody certificate you said? Where is the custody certificate is? Custody certificate produced by the state reveals that the petitioner has been in custody since
6 years, 4 months.
as on
6 years, 4 months.
as on
As on 13/3/2026.
2026. That's it. Learned counsel for the petitioner drawing the attention of this court to the evidence of PW10 oblique the victim who was 60 years of age at the time of commission of offense submitted that it is admitted on record that the petitioner has which part do you say that there was a past enmity?
PW 9, the daughter informant.
10 and 9, huh?
PW 9.
The bits that yes. Which part to me?
Daughter. Cross examination will also.
Yes.
PW 9 cross examination at least 45 will also.
Yes.
It is a fact that there was dispute between my mother and
Yes.
the mother of the accused before 15 days of the occurrence.
There was a dispute between who is this PW9?
Is the informant, that is the daughter of the victim.
Drawing the attention of this court to the evidence of PW9, who is the daughter of the victim, brackets PW10. He submits that in para 5 of his cross-examination, it is admitted by her that there is a dispute between the victim and the mother of the accused before 15 days before the occurrence. 15 days before occurrence. PW10 is the victim and who was 60 years before, 60 years before incident. It was also brought to the notice of this court the evidence of PW12, who is the doctor who examined the victim on the very next day of the occurrence. The doctors opined that there was no external injury to the who has examined the victim.
PW5.
PW10 is the victim, Your Lordship.
No, five is the doctor.
5 is the doctor.
It is showing 5.
Who examined the victim.
Sorry. No.
Yes, sir. No externally in the body.
Brought to the on the same day. It was examined on the same day. It is found, he stated that there was no external injury on the body part, grade VA to VIT was normal. On examination of genital, there was no perineal tears, posteriors, commissures, and fortune, and 6 stones of intake. M1 is measured on the vision of the junction diluted 2 fingers. It's also dry vagina due to 4 fingers. Vision sexual intercourse cannot be excluded. It is also deposed by the doctor that the victim is already attained the menopausal age. PW12 is the doctor who examined the petitioner on the next day, in the very next day. He has opined that there is no injury on the glans penis, and there was no sign or symptom of any recent sexual intercourse. Taking into consideration the nature of evidence and the period of custody of the petitioner, I'm inclined to enlarge the petitioner on bail, particularly because of the reason that the appeal is pending since 2021, and there is a blink chance of the appeal being heard in the near future, and substantive part of the sentence has already undergone by the appellant. 52. Yes.
Okay.
Yes. Next.
52.
Yes, sir. Yes. You are appearing?
Yes, we now, man.
Yes. 10 years sentence. Get that
10 years sentence, man.
3
And
education. I'm getting the custody certificate first. Okay. Please sit.
So that may be fixed, madam.
I will give it. Yes. Next.
Be issued to the because it's a POCSO is.
The POCSO is there?
POCSO is not there. No POCSO is there.
POCSO is not there?
No.
Okay. Next.
53. Also that may be fixed, man.
Yes.
53. My lord, sort that.
We'll give it. Wait.
My name may be recorded, my lord. My name may be recorded.
Yes, give in 50. Yes, next.
Yes.
53.
53 on behalf of Mr. Ghade.
Sorry?
I for interim bail, my lord.
Interim bail.
Yes, my lord.
IA number?
One two five two of 26, my lord.
125226.
Yes, my lord.
Interim bail for a period of 3 months. For what?
For with his father, my lord, is in the old age, suffering from old age elements, my lord. But he has been bedridden.
Have you filed any documents?
Filed documents, Annexure 1, candidate land.
What is this document?
This document is a disable certificate.
Huh?
His father's disable certificate.
Disable certificate is not for the.
Disable, it is not He has been disabled from, I think it is from.
But the petitioner also earlier enlarged on interim bail for a month, 2 months later.
No, for interim bail, urgent thing should be there so that you can be
Right.
released. Come on, merit. What is the period undergone? You tell me.
Total period means 5 years, 9 months.
5 years?
5 years, 9 months, 14 days.
Out of
14 years.
No, 14 years.
14 years. You get that custody jail conduct and okay. Just think of the main bail application. Yes, next. See.
55.
Yes.
The main bail application is also pending with that.
I will examine that one. Yes.
Although he has not filed any document, but my instruction is that his father is in bedridden only for 2 months. Is
Get some medical document, then I can.
Urgent this, I will take the
I
instruction.
have already urgent. You move the application.
Yes.
File the document. I'll consider it. Yes.
55.
55. Yes. Yes, madam. What is this? Bail. Interim bail.
Item number 56.
This is 56.
55.
55.
The conviction is of 25 years. And 25,000.
First death anniversary of his mother.
But no one is appealing.
Date is not given. Death anniversary, 24/7/2026. It is already gone. Already gone.
Victim is 5 years old. The victim is 5 years old. 376 AD. And 6 Oxo is that.
Issue notice on the application. Application to be served one of the offenses POXO. Issue notice to the victim from so. Meanwhile, the state to obtain the conduct certificate, custody certificate, and all. Take please the matter. Next. Yes.
56.
Yes, madam.
I don't know. The last time I will appear spelling mistake in my name. That is Bhakti Sudha Sahu. I is missing in that. Accordingly, I will also file a memo. It is not considered.
Since my learned senior is there, she was not present last time.
What was the spelling written there in the?
My lord, I filed it the bail only.
Madam, I tell you, once you are appointed Jamaica Security, it is a larger responsibility. You leave other thing and come.
Yes, ma'am.
Because you have volunteer yourself.
Yes, ma'am.
And your name is reflecting and everything, you don't come.
My name is wrongly recorded.
What was written?
Bhakta Sudha. That is Bhakti Sudha.
Acha.
That is a
Fantastic plea. Very fantastic plea. But since you are not there, I have requested him.
yes, my lord.
This is very embarrassing situation for anyone.
By the note.
Please give it handed over now. At least.
Letter,
Okay.
I may be excused.
Yes, start now. By order receipt bank 10/2023, Mr. Bhakti Sudha Sahu was appointed as a Jamaica Security to assist the court on behalf of defendant. However, on 22/7/2026, he didn't appear. Therefore, he was dropped and Mr. Sudipto Wanda was appointed in that place. However, when the matter is taken up today, Bhakti Sudha Sahu Amicus Curie had appeared and submitted that since her name was not properly not spelled out in the cause list, he missed it. Be that as it may, Mr. Ponda submits that he has already prepared a written note of submission pursuant to the order dated 22/7/2026. He has handed over the same to Mrs. Sahu, who shall prepare the matter, meets the matter. Look at the next week. Next week. Yes. I record the appreciation for the effective assistance rendered by Mr. Ponda. Yes.
57.
May I please, Lordship? Lordship, FIR has been registered on charge sheeted 302, Lordship, but convicted under section 3042. That is 10 years of imprisonment and rupees 5,000.
What is the period undergone?
Lordship, that is, he has undergone more than 4.5 years. And there is also pre-retention period under section 428, that is more than 1.5 years. That means
5 years. More than 5 years.
6 years.
Or 6 years.
6 years, Lordship.
Yes.
And Lordship,
Eyewitness?
there is no eyewitness, Lordship, but the case is stand by on 3 eyewitness. That is.
You see, no eyewitness against 3 eyewitness.
Yes, but there is. Lordship, kindly glance at the deposition of those eyewitness, alleged eyewitness.
Who are the eyewitness?
Yes, Lordship. That is
PW?
PW 6, 7 and 14.
6. Let us see 6.
Yes, Lordship.
What is your name? Your name is? You are Naveen. You are Naveen. Okay. Yes.
PW 6, Lordship. I know the informant Hemant Gadava. I know the accused Nabin Amatya who is standing in the dock. I know the deceased son Jema Amatya. The case incident took place on the date of Holi festival this year. During afternoon hours at about 2 p.m., the occurrence took place inside the house of the accused. On that day at about 1 p.m. in the afternoon, I saw the accused Nabina.
He saw you assaulting his mother Jema.
Yes,
and inside the house.
Yes, Lordship.
Then I intervene and I ask, I cannot assault the mother so and so.
Then
directly he has seen.
Yes, Lordship. Then Lordship glanced at that, and then the accused went away from his house. I left the house. Then I went to take my bath and returned after half an hour and found the accused was inside.
Yes. He has seen you. Next.
No, Lordship. At the time of incident, she was not there.
Assaulting.
Yes, only his.
I saw the accused Nabeen assaulting his mother Jema.
Yes, Lordship.
Then
I went to take my bath and returned after half an hour and found the accused was inside his house along with his mother. And at that time of accused had bolted the house of his.
Okay, it's all right. Next witness.
Lordship, that is PW 7.
Yes.
Lordship, that is contradictory. That is that Lordship.
Contradiction is later on. I'll see. Just
6 and 7. Lordship.
Previously, the accused.
The case incident.
Bit of assaulting.
Holy festival on the day. Lordship, kindly glance at that. On the day of Holy festival at about 12 o'clock noon, I found the accused was assaulting his mother. But PW 6.
You have killed your mother.
Yes, that is there, my lordship, because eyewitnesses.
But no eyewitness, Lordship.
You have killed your mother. So therefore, no bail.
No, Lordship. Lordship kindly, Lordship relied on the 3 eyewitnesses. But Lordship, they are not. Lordship kindly glance.
September. No.
Position of 14.
You have killed your mother. Nothing doing. No leniency. Yes.
But Lordship, if there is no eyewitness.
What kind of son you are killing, and your brother and sister have seen you killing your mother?
No, Lordship, they have not seen me. And Lordship, kindly glance at the deposition of 14. Who is my son?
Your son?
Yes.
14 years.
Lordship, kindly glance at his deposition. The case incident took place on the date of Holi festival this year. On that at about 4 p.m. Lordship, there is the contradiction of time, Lordship.
Madam, contradiction and all, I will hear you if you argue on appeal. For the purpose of bail, there are 3 eyewitnesses and you have killed your mother.
But
that's enough for rejection of your bail application.
Lordship, the deposition of 3 eyewitnesses is contradictory to each other.
Contradiction that can be seen when the appeal is heard. Are you interested to argue the appeal?
Yes.
I'll reach it. When is the appeal? What is the, which year appeal is this?
23.
24 appeal. Wait.
23, Lordship.
23 appeal. Okay, 23 appeal.
He has already undergone lordship 6 years.
23 people. Next week. ठीक है. Okay. I'll list it in the weekly. Come with your written note of submission. If you have a good case for acquittal, I'll see, examine it. Okay. But no case. Okay.
In his date lordship.
Date in it. Yes. 10, 8. Yes. Next.
Obvious.
58. May please proceed. An application for interim bail on 9/7/2026. Notice was issued.
Interim bail.
Yes, madam.
Yes.
The ground of operation of the brother of the present petitioner. The notice was issued on 9/7.
Yes. Yes, madam. Service. Have you served or not?
Sure, that part is not there.
That's why notice was issued to the victim. Respondent serviced on her has not been affected. Hence, one more opportunity granted the state to serve the victim, public informant, through the IIC. To release the matter after 1 week. Yes. Next.
59.
Yes.
My lord, offense under section 22I DC of NDPS Act, appellant in jail custody more than 5 years. Half of conviction, 10 years conviction.
10 years conviction.
Including benefits.
Get the custody certificate, antecedent, and jail conduct. Yes.
60.
Fixed for hearing, my lord. Well, item 59. Fixed for hearing.
No, I'm asking you to get the custody certificate, jail conduct, and antecedent. Because it is a NDPS case. Let us see. Yes.
That's in item 6 time praying for a short adjournment.
Adjournment request September. Yes. 15 days. Yes.
61.
The lordship.
Yes.
Not on the merit of the case right at this moment. During pendency of the appeal, my lord, I have filed one IA, that is 1748 of 26.
1748. Yes.
Lordship. For interim bail for a period of 1 month. Now the mother is suffering from different old age ailments, my lord. I have annexed this.
Mother is suffering.
Lordship.
This,
And
IA copy.
let them verify this.
IA copy.
Copy give.
already solved.
1748. This is an application moved by the appellant seeking interim bail for a period of 30 days.
Lordship.
A period of 30 days on the ground that his mother is terminally ill. And he has also enclosed a medical document to that effect. Issue notice with the State Council to obtain instruction regarding the same after verification of the health condition for the mother of the petitioner. Leaves the matter next week. Give the copy, sir. Copy, yes.
62.
May I please alert? I filed an.
Hey, what is the 1 minute? Please come. I'm sorry. What is the disease? Let us see.
Cardiac problem, my lord.
Is it very serious?
She was undergoing treatment in AIMS, Bhubaneswar. And that is my instruction law.
Shall I allow it subject to verification? The trial court will verify and grant. What do you say?
Only 2 days time, maybe.
Okay. Otherwise, I can allow this.
If
Saying that the trial court will verify the authenticity of this document, and 30 days only he is asking. What is the offense you involved?
376 years in custody. 20th July 2020.
Undergone period?
20 years.
20 years sentence.
Now
undergone 7 years.
7 years.
Verified. Okay. Yes.
62.
May I please alert? I have filed an IA number 1580/2026 for interim bail for a period of 1 month for his wife's illness.
Which IA? 1583.
Yes, my lord.
Interim.
What is wife illness?
What annexes? Wife is not well. Chest
Interim
pain.
chest pain, cognition, breathlessness.
Oh, this is very common thing. Yes. Some parameters are wrong. Verify the same thing. Same order. Next week. Yes.
Hon'Ble.
63.
Milord, I'm appearing online. This is an appeal against the order of conviction of the learned district and FTC POCSO Jaipur dated 27/3/2025 milord, and I have been undergoing incarceration since then. In total, 3.5 years of incarceration. 3 ବର୍ଷ 7 ମାସ ହେଲାଣି madam, and this case where both the petitioner daughter, the prosecutrix and the accused, both are married milord. The FIR in this case was lost only after the birth of the child. This is not at all a solo act, and only after the birth of the child, the FIR was lost by the father of the prosecutrix. She is not the victim, rather I am victimized. The falsity is embedded deep in the roots of the case, milord, because the FIR is lost by the father, who narrates that I draw your honor's kind attention to the FIR, milord.
Mr. Mohanty, you moved an application for interim bail. Are you pressing that or the main bail application?
I may be allowed to go for final hearing also. The interim applications may not be pressed, sir.
Okay, if the final hearing, then I'll have to include it in the weekly list. Then I can hear.
Yes, milord, that would be better.
Prepare a written note of submission.
Milord.
Get ready next week. I'll include it in the weekly list and hear it. If you are not interested in the bail.
Yes.
If you want to argue on bail, that's a different story.
No. I will be
finally arguing the appeal.
Yes, milord.
Okay, that's fine. Right on. Mr. Mohanty, learned counsel appearing for the appellant submits that instead of pressing the bail application as well as the interim bail application, he would prefer to argue the appeal finally. Hence, he submits that the appeal may be set for final disposal.
Lordship, one thing, the paper was not prepared. If a digitted copy may be deposition, other things.
Yes, you can take it. TCR is it. The trial court record, the soft copy of trial court record is already on record. In view of the submission made by Mr. Mohanty, since the trial court record is already there, matter is ready for, the appeal is ready for hearing, release the appeal for final disposal in the week. And yes. Okay.
That item 40, the lordship was inadvertently posted to 21st of August instead of 21st of July. The lordship has asked me to file a preponement petition. I have filed that. The government says that they will take some 2 weeks time to.
That is what this is blessing in disguise for you.
Yes, that maybe I am not.
Let it be 21st. If they file it, then immediately.
We commencing 10th, so that
if it will be 21st, if they file the closure report, you mention same day I'll take it up. The day they will file, you come and mention same day I'll take it up.
If they do not file,
then 21st I'll say and see.
Because case there is nothing.
You don't pressurize them, or you know what happens.
I'm not pressurizing at all, man. The urgency is
then there is no urgency. Investigation is going on, there is no urgency. They have made a statement that they are going to file a closure report. If you create problem for them,
no.
They'll file a charge sheet. You want a charge sheet, then I'll.
They are in my favor. Why should I create problem?
So don't create pressure. Don't create. 31. If they are filing in between, you come and mention. I'll take it up on the same day. Simple. Let it be on 21st. If they file, when are you going to file tentatively? You file it. The moment you file it, intimate. So
was assured on that before this honorable court. So we'll take instruction.
But see, IO has told that we are going to
We'll take
silence
Instruction also.
if you create unnecessary
No,
pressure,
no.
and the senior officer will say that file a charge sheet, we'll see.
It is in my favor. Why should I
So
give it?
please hold on. Please hold on. Let us wait. Yes. Yes. Next.
65.
Item 64 is there.
64, my lord.
This is my first case.
64 second item is taken.
Yes. 64, he is short for it.
Adjournment.
Adjournment. First.
3 items is there. 3 items there. I have not taken time in my first item is in my.
Arising out of same incident. Exactly.
When did they all three matters, I'll take it up. Mr. Sahu, Jyotirmay Sahu mentioned it in the morning.
Kindly fix a sorted.
We are giving only.
Sorted, my lord.
Sorted only.
Okay. Another thing is, my lord, the sub item, second sub item is, my lord, JCRL. Lord, I may be supply a.
Take the soft copy. Take the soft copy, no problem. Yes.
And my name is, my lord, full name is here. My lord, the only K Mohanty is mentioned there in cost. For this.
Full name written. Yes.
65.
Manner. Then in custody manner, 25/8/20 manner, conviction 10 years. 6 years in custody manner. Order dated.
Custody.
Order dated 13/1/26.
And antecedent.
Order dated 13/1/26.
Receive. So counsel for union of India, they have to serve your copy. They are on the perhaps.
And NGV matters.
My lord, order dated 13/1/26. Can leave it in glance, my lord.
Yes, it's already there.
Yes,
The order is there. Already there. Who is appearing for NGV? It's a party supposed to appear. I'll pass it over. Let us see if this party may come. Yes.
Sub item is same, my lord. Same.
Let it
Yes, ma'am.
passed over. Yes. Next.
66.
May I please, Lords?
Yes.
The petitioner's files for interim bail on account of his mother's death, Lords. Tag D, Lords.
Earlier, you have been granted interim bail.
My lord. Earlier on account of his father's death, interim bail was granted.
Death of his father.
Yes, surrender and surrender certificate.
Surrender certificate you have filed?
No, Your Lords.
Surrender
File
certificate.
whether you surrender or not, we don't know.
My lord, I have one day time may be given. I will.
What? By order dated 6/1/2026, the appellant was granted interim bail. Interim bail for how many days?
Six one eight was
Period
filed.
of interim bail for how much?
6/1 order was passed. 6/1.
I know, but the interim bail for how many days?
3 weeks. He was granted 3 weeks. Yes.
3 weeks. But although the petitioner was, appellant was enlarged on released on interim bail, but he has not filed the surrender certificate as yet. NC 6/1 will time to file. Release the matter after 2 weeks. Yes, next.
Lord,
But he surrender, file the surrender certificate after we'll see. Next.
67.
But 2 days.
67, yes.
May, let's say last occasion I have a bail, one month interim bail and a surrender is pretty court bill. Surrender certificate already filed.
Yes.
Lordship in CRLA 1297.
Let him complete the, yes. You are appearing in the first matter, huh?
Well,
First matter, yes.
it's if the appellant was convicted offense under section.
No, now you are pressing for the regular bail.
Well,
Yes.
it's the appellant was convicted.
But the period of custody?
It's more than 2 years.
Let the certificate, na? Custody certificate, delegation, and yeah. Next item.
Lordship in 1297 also We are on interim bail for a period of 2 months on the health ground, Your Lordship. And we have filed also an interim application for extension.
Have you surrendered?
Lordship, we have filed an interim bail for extension of.
Extension for what?
They are interim bail, Lordship. They are under treatment. The appellant number 3 is suffering from tuberculosis.
The interim bail was granted on
25, 2026.
20th.
They are released on 24
for a period of
2 months.
7, 2026.
For a period of
2 months.
2 months.
2 months. It is expired.
On 24 it's expired, Lordship. For this.
Have you surrendered?
Lordship, they are at Bhubaneswar. They
You first surrender, then only the second application will be considered. You surrender. 2 months, you can't, but order dated 45/2024, the convict appellant was granted interim bail for a period of 2 months, which expired on 24th of July. It is when is the extension of time application?
Lordship, we have filed it on 2027.
Where is that application? Number
1818 of 2026.
1818. That is not there. Okay.
That is for extension of interim.
But that is application is there. But the counsel for the appellant submits that he has filed an application for extension of time, for the interim bail on.
Filed on 20th/7/2026.
The application is not on record. In any case, since the interim bail period has already expired on 24th, the petitioner shall surrender before the concerned bail authority and file a surrender certificate. Thereafter, only the application for further exchange, further grant of further grant of interim bail shall be considered. Okay. Lease the matter after 2 weeks. Yes.
68.
Last time Lordship called for the office certificate at the practitioner Lordship. And out of 10 years, he has already received.
Yes.
Custody certificate received. 4 years, about 4 years in jail custody Lordship.
This one on the. Yes.
3 years, 11.
Total
1206.
Means how many years?
7 years, Lordship.
Huh?
7 years.
7 years? No. 1, 2.
Convictory 7 years, Lordship.
Period undergone.
Period undergone 3 years, 11 months.
3 years?
11 months.
3 years, 11 months.
11 months, Lordship.
Okay. 7 years conviction. Sentence, okay. 7 years sentence.
7 years.
7 years sentence. Sue me now. Evidence. Yes. Jail conduct is also satisfactory. There is no antecedent, criminal antecedent. Isn't it? Let us see what are the evidence. Yes. Yeah, eyewitness.
Eyewitness may not 1, 2, 3. They have not supported the prosecution before the IO Lordships. And
who is the eyewitness?
Pedal 1, man.
One. Okay. What's your name? Your name is Prasanta Kumar Mahakut, PW1.
My lord, by taking liquor, he assaulted his my lord, fist kick blow my lord on the chest and head of the lord. As a result, the head of the father-in-law is hit in the wall of the house, my lord. He became unconscious and thereafter
fist blow. My father-in-law sleeping.
No bleeding, nothing. Only trauma is there, my lord. Actual medical report is concerned, lordship. Only no injury report is there, lordship. Only so far medical is concerned, my lord. Period 11. Was the death is due to blunt trauma.
304 part 2. And who else?
And also DW2, my lord. Sanjay Kumar Pradhan.
Yes, of course, people in the house, and I saw the accused came and assaulted his father at that time, and I was standing in the roof
of my friend's house.
There was there are direct evidence.
They have, my lord, assaulted by means of fist kick blow. No intention.
Therefore, 304 part 2. Otherwise, it should be 302.
Not 302, 304 out of 7 years, or 4 years.
That is one of the consideration, but you have killed your father.
Difficulties, lordship, my lord, as per instruction is concerned, the wife has left his, my lord,
if this kind of man, he was fully drunk and assaulted his father in presence of all the family members, and the father died.
Immediately
Where from I'll get these things? Why should you file an affidavit? Bring those things on the court. Order dated so and so. The State Council has placed on the court the conduct certificate and custody certificate.
My praise, let call for the IO to file this petition.
No. You file affidavit. This is easy to jail criminal.
In jail custody, that's actually problem, my lord.
It is a jail criminal.
Yes.
Land Council put the petitioner submit that the petitioner two minor sons.
Yes.
Minor sons, and there is no one in the family to.
The wife type
and the wife of the petitioner is also left his matrimonial house. And let the State Council obtain instruction through the IIT. Which police station?
Yes,
IIC Sadar Police Station,
Sadar Police Station.
Sadar Police Station, Keonjhar.
Release the matter of 2 weeks. Get a report. What is the family status and all? Yes, we'll see.
69.
Yes. 69.
Wait, please, Lord. The appellant is in custody since 9/5/2021, and wherein till today he is in custody, but twice he has been released on interim bail, and he has almost completed a period of 4 years, 11 months, and 20 days, Lordship, and his conviction is 10 years, Lordship. Initially, FIR was lodged under Section 30.
So let us get that custody certificate.
Custody certificate I have, Lordship.
And no antecedent and jail conduct.
No antecedent is there, Lordship. May I kindly have a glance at the custody certificate?
You have that. Why you not filed it? Yes. Jail conduct?
To that aspect, I don't have instruction.
Get the jail conduct. Any certificate you get. Yes. Least up to 2 weeks. Yes. Next.
Item 70. Your Lordship may kindly have a glance to two last orders. 27/2026 and 11/5/2026.
Yes.
11/5.
This is an appeal. He doesn't want to argue. What do you want to point out?
He is praying for this hearing of this stay of conviction. So he is taking time.
No. I'm not going to stay the conviction.
He has been dismissed from service. I have attached the flag D.
So I'm praying for a short action.
Either you argue the appeal,
no,
or ask. You are on bail. So argue, ready for arguing the bail. Forget about your conviction. Stay of conviction, not possible.
Let it be added, a usual course, let it be added to the hearing list.
Usual course. Yes.
And preparation of paperwork.
Yes, please.
In usual course, let it be taken up for hearing.
Yes.
71.
For finally. Yes.
I have carried that order of government taken against the order of the government official. The vigilance.
Yes.
In 131 the page.
131 page.
Yes.
So
you're challenging the cognizance order. Yes.
My lord, my son was the assistant engineer in Tupinda NS. The legal department found JSG the disproportionate asset of my son, that is 113.72%. In the FIR, they have taken into account four houses, my lord, out of which, my lord, one houses does not belong to my family at all. One house was sold, that serial number 3 was sold by my husband prior to his death. Two houses remained that were constructed since 50 years ago by my husband. And
you are the mother of the principal accused.
Principal accused.
Okay.
And in the FIR, they did not make me accused. After when charge sheet was filed, they have issued notice to me. I appeared at the accused file. I have given the income tax. My husband was a contractor, my lord. And I myself and my husband were running a Sambalpuri Bhaktaralaya at Chuchinda. I have filed the income tax since 1965 to 66 till date, my lord. Those have not been taken into account as well. I have been shown as that. That the public document I have filed on the Annex 7, my lord.
Show me in the charge sheet.
In the charge sheet, my lord, they have said.
What is alleged against you?
Charge sheet copy has not been shown. And I have. Annex 3.
Yes. Which part?
36. Annex 3, I think.
Who is the check period? Check period is?
My lord,
Check period.
Period, my lord.
Check period.
Check period, they say that my son entered into service in 1990 as Adak employee, as a junior engineer, regularized in the year 1992, my lord. And you were promoted as assistant engineer in 2000.
You tell me the period.
Period from 1990 till my lord, the date of filing the. And all my property FDR they have shown, they are my lord prior to my son joined in service.
So which are the from the charge sheet you show me which are the property belongs to you which has been included in the charge sheet.
Yes, my legal estimate kindly see at page 35 they issued notice that I am an accused and charge sheet was filed on the Annex 3 my lord. You lost it kindly come to page 37. Serial number 10.
10.
Yes. That is a SB passbook account. Then serial number is a passbook account. The amount was kept in first serial number 10 is minor. It is 64,064 rupees. In serial number 11 minor, the amount is 25,300,818 minor. Then my next page.
Serial number 11 25 lakhs. Serial number 11, the account which is reflected Punjab Nationalized Bank, Kuchinda branch.
25 lakhs.
Where is the statement? Bank statement. Show me which period you have deposited.
That was deposited since long before the time of.
Show me that statement at least.
That bank statement, my lord.
Then how will I know where from the money came? You are 86-year-old women.
6 years, so you lost in kindness Annex 7, my income tax is 60%.
But I want to see the statement.
I'll find money.
Then unless you show me that this money has come from my own business or something of that, you are 86-year-old woman. And whether you are continuing the business or not, or your son is earning the money and depositing in your account.
Yes.
That has to be seen. Yes. How will I know?
I will show. I will find.
Now cognizance is only taken. Do one thing. You argue all this thing at this. You move an application before the trial court. Let the trial court examine. You file everything.
Yes.
You file discharge application. See, you are 86-year-old woman.
At the company state, the trial court will not hear at the time of the time of framing the charge.
Therefore, I am saying I will direct the trial.
I will file all the statements here. Fine. I'll file.
Why?
She grant me a trial,
See,
I'll file.
that exercise could only be done by the trial court at the time of consideration of charge.
Coming up the charge.
And then you argue it.
But
I will
my
give that liberty.
I was not accused at all, my lord. My parental house was taken, the communities had been taken, my lord. Therefore, my lord, at this age, I will go to the court, my lord.
Prima facie, by seeing item number 10 and 11, I'm sure that the cognizance is
I'll
right.
file that statement, my lord. That means.
So therefore, I'm saying, sir, you file it and I give you liberty, move an application, satisfy the trial court, ask for a discharge. I will direct the trial court to deal with all the documents and pass a detailed order. Because cognizance order is not a detailed order. Because cognizance order, he has only to see prima facie case is made out or not. He has rightly passed the order. I will give a direction. I will give a direction. The trial court should to consider everything. You move an application.
Let's, he has to file an application for discharge. He's experienced.
Yes, along with an application.
But so far the materials which are at his possession but not part of the charge sheet, my lord, he has no right.
No, he has filed you try to appreciate one thing. She is a 86-year-old lady.
That's him, Lord.
And son has done something.
I wish
the old lady is now made in
I wish had he preferred 482, I understand, Lord, because of the age factors.
Technically, problem is cognizance order. Let him move an application, let the trial court decide everything.
But if he file an application, my lord, if he files an application, this has no problem.
I'll pass it.
But so far, giving handles to the petitioner, I'm not accused to produce any document at his possession which are not part of the charge sheet. Well, that's a legal problem.
But see, the problem, you must appreciate one thing. Problem with your department is you pick up everything from the house and whoever is there without analysis anything, you make everybody accused.
No,
and they will keep on fighting the case throughout their life.
Yeah,
she's 86. Let her die peacefully.
I agree, Milord. On that point, Milord, I wish had he filed an application 482, Milord. But
so that is
the scope.
That's the problem. 482 to 238, all sections you will tell. By the time she will die.
No. In fact, this is a misplaced one. This is what I suggest.
This is the reality. Once you file a charge sheet, somebody is an accused.
That's a Milord. I suggest.
At this age, just imagine.
My submission is, Milord, I agree with your lordship, Milord. Let him raise all those, but file an application to be discharged, Milord.
That is what I'm saying. I will direct to dispose of the application which he is going to move
if he files
within a time frame. Because she is 86 now.
But the trial court cannot go beyond the charge sheet.
Trial court will see that.
Cannot go beyond.
Trial court will see that. Okay, I'll pass the order. Give it. Okay.
Sir, extremely sorry, sir. Item 55 of the argument.
I'm in 71 now.
Can it be taken up tomorrow or day after?
I don't know what I.
Most difficult created listed.
See, there are many stenos are coming. I can't call everybody who is taken.
Only to appreciate. Sir, it was
this is no way, sir.
Sorry.
Only and I don't know who has taken dictation. I'll tell her something. She will type something else, and all confusion thereafter. Wait, he should have come.
The case.
Yes.
Also dispose the matters.
Yes, I'll dispose up with that direction. Yes, sir.
No liberty is required, but on his submission, let me find application. No liberty is required.
I'll balance it. Don't worry.
He has got accrued the right to file an application.
Don't worry.
My honorable question: what is the scope of the trial court file?
Yes.
What is the scope?
This is scope is very limited, confining to the charge sheet.
Yes.
Not charge sheet.
Yes, sir.
72.
The opposite party is allowed by the judgment. Yes, sir. You have challenged the order dated 24/11/2022 passed by the District Consumer Forum.
Yes, my lord.
Against the same order, you filed a appeal before the State Consumer Forum, which has been dismissed. And now you file a writ petition also.
Actually, the actual matrix lordship, the opposite party has obtained
I am not on merits. Against the same order, you prefer a writ petition and you also file a appeal.
Yes, sir.
Appeal is the right remedy that has been dismissed.
Yes.
Against that, other remedies are there, Why writ petition?
Yes, the other remedies are
It's very far away. You have to go far away.
That
therefore.
limitation also passed, Your Lordship.
That is a different story, sir. You have to explain the delay there. But you can't file a writ petition. How the writ is maintainable?
But that's what also approach to Your Lordship.
It is not maintainable. That's the problem.
The petitioner will have no any other remedy, Your Lordship.
But sir, you have a remedy?
Remedy to the National Consumer.
National Consumer.
The Supreme Court.
That is the Lordship. Who must delay, Lordship?
You have to explain there the delay.
Lordship, maybe liberty may be granted, Lordship.
Why? You, the writ petition itself is not maintainable. Writ petition is not maintainable. Huh? Right. Already correct. By the, on 22/7/2026, the matter was heard and the following order was passed. Since none appeared on none appeared for the petitioner on that day, matter was listed today. Confronted with the maintainability issue, the counsel for the petitioner satisfied this court. Therefore, the writ petition is disposed of, but dismissed as non-maintainable. However, dismissal of the writ petition shall not preclude the remedial right the petitioner has against the impugn order. With this observation, petition is disposed of. I have recorded. You have all procedural remedy. Okay. Yes.
74.
Procedural remedy under the consumer protection.
What's my asking on the behalf of Scenario Bigyan Jama?
74. Sorry, 74. Yes, sir.
Sir, I need a short adjournment, sir.
Any stage operating?
Sir, there is one interim order.
Interim order is there, then you argue.
Sorry, last I have no.
No, you interim order is there, then you have to be,
So Wednesday, the day after tomorrow also.
Have you deposited 20,000 rupees?
Sir, I have no instructions.
What is this case is about? It was dismissed in default. Thereafter, it was restored, subject to payment of cost of 20,000 rupees. That was restored on 13/3/2025. Where was the interim order? Oh, there is an interim order. I can't. See, you took an interim order and you enjoyed for years together. The interim order was taken in 22 and you enjoyed for years together. Thereafter, it was dismissed in default and you moved application. I restored it. And along with the restoration, the interim order also got restored. And you started enjoying it and it will go on for another 5 years. I'll vacate the interim order and come and argue whenever you like. Once you take an interim order, just see, all the judges have retired and everything has happened. Now you are enjoying. It is not nothing doing. Tomorrow. Day after tomorrow. Huh? Day after.
One prayer. Here I am appealing for the opioid illness. One extra copy we serve on him. What extra copy do
you allow him to enjoy the
day after tomorrow?
What extra copy is it is going on since 22. Today we are in 26. Now you extra copy. That is how these interim orders are being used by them. You should be the first person to oppose this. Since you are not opposing, it is going on. And you allow him to enjoy the interim order, let him enjoy. I'll put it in September.
No, let it come in day after tomorrow. Today.
Why should you say that you don't have a copy? Then you have been arguing the case since 22 without having copy.
No. Copy misplaced somewhere from last occasion.
Very, very surprised. Take a copy, soft copy from here.
Yes.
If you are depend upon him, he will never give. Because he is enjoying interim order, why will he give a copy?
Come there.
Take a soft copy day after tomorrow.
Miller.
I'll dispose it upon that day. Yes. Otherwise, I'll vacate the stay. Vacate the stay, then it will go on. Okay? Yes.
75.
May it please your lordship, I'm appearing on behalf of my senior Kishore Kumar Mishra. Your lordship, kindly grant a passover.
Is there any stay, madam?
Your lordship,
Same story.
lordship,
Stay.
passover, your lordship.
No, passport is better. Day after tomorrow. Day after tomorrow. Let it be day after tomorrow. Huh?
Lordship, interim order.
Day after tomorrow.
Interim order to continue, your lordship.
There is asking there is no interim order.
There is an interim order. 75, na?
Yes,
Yes, there is an interim order. Just see at the top. Interim order.
They are dismissed for default. Then
Interim order. See, interim order dated 28/3/2022. 28/3/2022 restored.
So 4/7/2023 order.
No. Just see that the interim order
There is
continues.
specific vacation of interim order. Lordship, can be 4/7/2023.
4/7.
23.
Accordingly dismissed for non-prosecution. The interim order passed earlier stands vacated. It's all right. Thereafter it was restored.
That Sierra Leone's was restored, but there is no whisper about the.
Oh, this critical analysis, you know.
That
It restored to the original file means along with the interim order it
Since
restored.
there is a specific vacation order. ହେଇ ନଥାନ୍ତା ତାହେଲେ ଏଇଟା ଅଟୋମେଟିକାଲି ରେଷ୍ଟୋର ହେଇଯାନ୍ତା ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରଟା ରେଷ୍ଟୋର ହେଇଯିବ ଯେହେତୁ there is a specific direction of vacation of interim order.
Where is the
Restoring
restoration
matter,
order?
this honorable court has not restored the interim order. I don't think according to my interpretation.
It is a matter again open to interpretation. Open to interpretation.
The day after tomorrow, the person direct the state council to obtain instruction as to whether charge sheet has been submitted or not.
Yes.
He has prayed for passing the FIR.
FIR quashing.
Yes.
What interim order then?
After 1 month after
No.
he has filed the CRLNC.
What is this interim order then?
Not
FIR
taken.
quashing. Only.
With FIR 12/1, he has filed the CRLNC 16/3. Thereafter he was arrested, he was in custody. After the submission of charge sheet, he was released on bail.
What is this interim order then?
Not to take any
No pursuit action.
action.
No pursuit action. No. This petition is pending since 2022. The petitioner, by invoking the inherent jurisdiction of this court, seeking quashing of the FIR. Huh?
Yes, this is a
FIR
proceeding.
Being Barampur Town PS case number 9 of 2022. By the order dated 28/3/2022, this court on 28/3/2022, while issuing notice to the respondent opposite party, this court has directed not to take any course of action against the petitioner. The criminal miscellaneous case was dismissed for thereafter on 4/7/2023, while 4/7/23, the criminal MC was dismissed for non-prosecution, and the interim order passed on 28 so and so stands vacated. Although on 12/10/2023, the CRLMC had been restored, but the order reveals that the interim order has not been restored back to the original file. This original file. And this Mr. Pradhan, Second Counsel, appearing for the respondent, opposite party. Opposite party submits that there is no clue as to whether the investigating agency has concluded the investigation or not. Since there was no stay of investigation. There is no stay operating against the investigating officer for withholding the investigation. It is expected that the investigating officer might have proceeded with the investigation, but nothing is borne on record to reflect on this as to whether the charge sheet has been filed or not. Let the State Council obtain instruction in that regard. These the matter on 13th of August. No, 14th of August. Meanwhile, you get the instruction. Because there is no stay, nothing. Investigation might have been completed also. Nobody knows.
He was in custody. He was in custody after submission of charge sheet. He was released on bail.
Okay. Charge sheet has been filed then. A charge sheet has been filed then.
Yes, but semane kona insertion mu to janche ka charge sheet hela par bail dele thi.
Okay. Then nothing survives then in this matter.
Senior.
Your Lordship,
14th, huh? 14th.
Your Lordship, then interim order should.
There is no interim order.
No interim order.
In fact, it is vacated long back. I am not saying anything on the interim order part. Mr. Mishra, yes. I have only stated the what has transpired in this matter, and I am asking the status of the case.
Yes.
Status of the case. 14th I am missing.
When my friend knows charge sheet has been submitted, was released on bail.
Today morning I was talking with him. Exactly, I do not know what is the stage.
Let the State Council say. Okay.
Interim order to continue.
There is no interim order.
There is an interim order.
See, it was vacated and it was restored, and while it was restored, there is no indication of restoration of. Yes. I have, just see, let us see. If you want to show me, show me.
I will very extend it. If your Watson not extend this, I am ready with your Watson hear the matter for either this side or that side.
Just see.
Yes.
See, the interim order was passed. Just see, interim order was passed on 28/3/2022 regarding no coercive action. What is no coercive action?
No, subsequently it is same. No coercive action.
What is no coercive action in a FIR quashing matter? Investigation can't be stayed. What is no coercive action?
The GR case has been stayed, subsequently it is modified. That order has been.
Show me.
Yes.
Where is modification? The interim order dated so and so modified to the extent that there shall be stay of further proceeding in GR case so and so.
Yes.
So and so.
My learned friend appeared and objected for which this order.
You say charge sheet has not been filed.
Yes. Till that charge sheet has not been.
Then how what is the stay then?
Milord, investigation is kept open.
How?
Civil suit is pending, Milord. In similar.
That's a different story. What is the purport of the interim order in a case where you are seeking for quashing of FIR? You tell me.
No, what's the
Can the High Court under 482 can stay the investigation?
No, it is not exactly.
Then that's what you are saying.
Learned friend appeared and objected in that line. That this court doesn't have the power to stay the investigation. In fact, that's why the order was modified.
And this order, which was modified, subsequently vacated. Just see.
Vacated, Milord. Once it is restored, Milord, automatically.
No. Just see. No. Restoration is not simple. Not restored to its file. Just see. Read the language. Read the language. It says CRLMC is accordingly dismissed for non-prosecution. The interim order passed earlier stands vacated. This is the order. And then you move an application for restoration of the same. It is what is restored? What is restored? The CRLMC is restored.
CRLMC
is restored. Where is the interim order? Having the interim order, specific interim order vacated, you should have said that time.
Subsequently, I have not brought that file, Milord. Perhaps, Milord,
that is what I have not said anything. Whatever is transferring from the proceeding, I have recorded that. I am not saying anything. So therefore, let it come on 14th that is ready for argument. Meanwhile, let him get the instruction. I can't pass the interim order.
This week, you are also going to take up this.
Okay, this week, okay, no problem. You tell me.
Thursday or Friday?
31st?
No, 30th.
30th, okay. 30th and 31st. 30th. Huh? 30th is dedicated bench. That I can.
Then you are also going to next week. Monday. Next Monday.
Yes.
Next Monday.
Yes. Third. Third, okay. Yes.
76.
Last date, actually, Your Lordship wanted that both the decisions to be placed. There is one more decision, this Dhana Singh's case, which I would like to refer to, which in fact goes against my case, in fact. In Dhana Singh's case, they have distinguished between the partnership firm and company. They say company may be a legal entity, but partnership firm cannot be a legal entity.
Because he is not a juristic person.
Juristic person. Therefore, any one of the partner also can be
prosecuted.
And
that was the preliminary view I had.
Your Lordship's view was also that. The only point that has not been discussed within personal capacity, that is exactly what I was pointing out, Your Lordship. But in this case,
this is Dhan Singh.
Yes.
Yes.
Dhana Singh. The Your Lordship referred to the Manmohan's case. That
yes, the other one.
I have also given a copy of it. But Manmohan doesn't.
That deals with the overall how to go about the matters. And
conclusion, if Your Lordship looks at that Manmohan's case, concluding but political portion of the judgment.
Yes.
They have really indicated some guideline.
Then a format and everything is given.
Yes.
Because this 138 become a headache for the judicial system itself.
Para 38, if Your Lordship looks at,
yes,
if the accused pays the check amount before recording his evidence, then the trial court may allow compounding the offence without imposing any cost or penalty on the accused. You got it? And other also.
See, Justice former Chief Justice had a judgment. This is little modified then. They said that in the trial stage, if you compromise, you have to pay 10%, then 15%, like that.
Here in the instant case, I'm filing an affidavit. What has happened? The entire consideration amount in the meantime has been paid. The check that was bound, that amount for which actually
already paid.
Yeah, that is what the affidavit shows.
Yes, what do you say? It's already been paid.
Filed a copy of the additional affidavit.
See the additional affidavit. If it is paid, then para 38
exactly
covered.
I got the additional affidavit and I verified later. In that affidavit, the petition also attached a copy of the affair. Lordship can see the affair. And in 15th line, the petition categorically mentioned that he has paid the entire amount in cash, my lord.
The receipts are there. The receipt
is disputed, my lord, because the receipt was manufactured, the signature was manufactured. The lordship can see. Okay. I have filed the bank statement of the opposite party.
You are
party.
Copy.
And the petitioner has.
You are Kiran Prasad, huh?
I am from Kiran.
1 minute.
Petition has paid
1 minute.
only 17 lakhs, my lord.
Kiran Prasad.
Through RTGS, my lord. That is the bank statement. The cost of the land is, my lord, 56,000. 56 lakhs, my lord. The petition has already paid 56 lakhs as per original affidavit. So again, what is the necessity to pay the more 17 lakhs through RTGS? From this, it clearly reveals that the document is completely manufactured.
Right.
FIR, Lord, you can see, page FIR on the line location categorically. They have paid the total amount in cash. This is my bank statement of Kiran Prasad opposite party.
Kiran Prasad, the vendor, letter voucher number so-and-so with an assurance to return back all the check and which is in acknowledgement so-and-so.
You have photocopy file करते sir. The original with the sir. Check up the original also.
This FIR was lodged on
4/8/2018. 18 minor.
When the check was deposited 10/2/2018.
ତାପରେ ପେମେଣ୍ଟ ହେଇଛି ଯୋଉ
ତାପରେ ଥାନାରୁ ଡାକିଲା ପରେ ଆମେ ମଧ୍ୟ ଯାଇ ଗୋଟେ ଏଫଆଇଆର ଦେଇଛୁ ଯେ ସେ ମାତ୍ର 17 ଲକ୍ଷ ପେମେଣ୍ଟ କରିଛି ଆଉ ପଇସା ଦେଇନାହାନ୍ତି।
Some payment you have taken.
Minor?
Some payment you have taken.
say entire amount.
So only 17 lakhs. That is my documentary lords. You can see take a glance.
Original receipt would have.
That is the bank statement. The
Left side.
has already paid 17 lakhs to adjustment in different dates. And
last-
I have marked the lords. You can see.
So what will happen if suppose a check, part of the payment you have taken,
Yes.
check amount, what will happen?
So there is a Supreme Court decision to that effect.
Minor?
If you say, okay, I accept to the fact that only you have taken part of the check amount,
So Supreme Court decision. So that
part of the check amount, not full check amount, then what will happen?
Then they have not stated that who check against केते पैसा दोचेन. I mean total amount.
But you tell me whether you have taken small part of the check amount. Suppose check amount is 1 lakh.
Yes.
Suppose you have taken 10,000 rupees
Yes.
towards the check amount.
There are
What will be the fate of the 130 case?
other 3 checks that there are 4 checks minor.
Then by you partly you have taken the money. See the receipt, original receipts are there.
That
Don't go into technicality. You may be problem again. So better you settle the dispute. If you have little here and there, let us be practical about it. Settle the dispute. I can send it to mediation and settle the dispute.
people also if you whatever the amount paid by the petitioner. You let it stated before the trial court, the authority because the signature.
No, then what you will say is, on the basis of the admission on your part that part of the check amount has been paid,
Then
the
138
sequence goes. Then you will be in trouble. Then it lead to some other consequences.
The Supreme Court says no, the proceeding cannot continue.
The petition has come to this court minor on under section 482 for quashing of the cognizance order. Only the plea, the farm is not injured as a party. And at the time of filing of the petition before the High Court, Hon'Ble High Court, he has not raised a single word about the regarding the payment. He has paid some amount.
No, you may be correct there, but now an additional affidavit is placed on record. Along with this thing, it has to be gone into. Once it is gone into, either I'll have to go into or I'll have to send it to trial court to go into. Then you will stuck. You will not get any money.
Additional affidavit sir se पहुंचंती इस पेमेंट करते हैं 56 लाख टका एफआईआर मतलब 15 लाइन they have category mention.
Yes.
But I have already given a documented certificate that the bank statement.
Please do. Give me 8 happen.
हाँ सेठी आगे देखंतु defendant 19/1/18 I have marked errors you can see 19/1/18 31/1/18 6/2/18 7/2/18 8/2/18 totally 5 date they have paid only 17 lakhs to RTGS. So my response submission
Cash ଦେଇଛନ୍ତି ବୋଲି କହୁଛନ୍ତି ନା ଆପଣ
କ୍ୟାଶ ଦେଇନାହାନ୍ତି ମତେ ଆଜ୍ଞା ସେତିକି ପଇସା ପାଇଁ ଯଦି କ୍ୟାଶ ଦେଇଛନ୍ତି ସାର୍ 56 ଲକ୍ଷ ତାହେଲେ ଇଏ 17 ଲକ୍ଷ ମତେ ଏକ୍ସଟ୍ରା କାହିଁ ଦଉଛନ୍ତି ଟୋଟାଲ କଷ୍ଟ ଅଫ ଦି ଲ୍ୟାଣ୍ଡ ଇଜ ଓନ୍ଲି 15 lakhs minor. Because the petition has taking the
wrong or right, there is some part payment you have taken. So better that
I have only taken 17. I have given
so part payment towards the check amount you have taken. Then the consequence will be little. I don't want to get into all these things. Then your case will be prejudiced. Better that I am sending it to mediation and you finish it.
Yes,
that's the best solution.
Yes.
Otherwise, your case may get prejudiced. Some lot of technicality will come in now. After accepting, you file the
notice. They have not complied.
There you are correct. The presumption and everything is operating.
In this case, so I have cited also decision.
Keep it. When I hear it finally, give it back. Finally, hearing I'm just. I will have an attempt for settlement.
Mediation
Mediation first. You affidavit count. You have filed reply to the affidavit?
No, they have not.
No, this is.
Mishra.
Sir, mediation je तथापि मैं negative file करते हैं.
I will not say anything on merit. I'll simply send it to mediation.
That interim order is there. that-
Interim order, I'll send it for mediation. Try, then you file everything and minute I'll discuss.
Settle कर दो तो जहाँ payment नहीं दो discuss कर दो.
Petition, this petition is arising out of a dispute regarding dishonorable alleged to have been issued by the petitioner. In this petition, the petitioner has challenged the order of cognizance of office, section 138 NIA taken against him. Since after hearing both the parties for a while, the parties have, the councils appearing for both the parties have jointly prayed for referring the matter to High Court Mediation Center. High Court Mediation Center. Let the parties appear before the mediator on 7th of August. 7th of August. And the mediator shall explore the possibility of a settlement and furnish a report before this court by 24th of August. 24th of August. Lease the matter on 28th of August. Lease the matter on 25th of August. 25th of August. 25th of August. Interim order shall continue till then. Mediation report as well. Supplementary. ठीक है. Total कितने मीटर है total? कितने मीटर total? 89. Oh, yes. So hearing, on hearing, yes.
Last hearing.
Next. Yes, next.
77.
77, 78, 79. All are equal matter, Lordship. For final hearing, I pray 1 week after 22, the case has been listed first time, Lordship. The lawyer brief I have to take instruction.
Therefore, more application that you should be
also since 2020 civil suit is there. The case, Lordship, the present claimant, the OP2, he has no legal liability. The father has leased out the crosser to me, my unit.
138 meters.
Yes.
Is there any
and
claim?
the father has claimed to file a suit.
Stay then.
21 from 21 the proceeding has been.
Other has been filed a suit that is since
All these things are tribal thing. Why should 138 court will see? 138 court has only to see.
The basic requirements.
Disputed. Notice was given. Reply is given or not?
No, that is disputed. Basic requirements of section 438. That is not for that only one chancellor.
I have not read.
I am not seeking any more time.
Listen, you know that I have not read. Let us read together. If it required, then I'll adjourn it. If it is not required, then it's simple.
The कोड़े अनुसार सूट तार पोजीशन कौन अच्छी के सेम क्लेम को सूट रे क्लेम बापा करचंदी पुओ एठी ना एक्टर करचंदी. Our stand is that the document has.
That is not the test for 138. 138 test is different.
Yes,
even if there is a civil dispute,
only one chance.
Made out.
Next week any day also मैं fix
day after tomorrow. Day after tomorrow.
Next week any day.
No, next week day after tomorrow. Day after. See, these are 21 you have obtained stay and going on and on.
20,
in 138 matter.
22 not about next week any day.
6 years. Nothing doing.
Next week any day.
No. Day after tomorrow. Day after tomorrow. Day after tomorrow. Otherwise, I'll vacate this thing. Have you seen the judgment of Supreme Court?
They
are replicated the manner in which the stay are granted by the Supreme Court in 138 matters.
Day after tomorrow.
Yes, day after tomorrow.
Interim order continue.
Come with a full preparation?
Yes. So only for that
day after tomorrow. Next.
81. Interim order continue. All 3.
That is the reason it is getting adjourned. Anyway, day after.
Add them together. Because
all the 3 matters. All the 3 matters. Together you prepare.
76, 77, 78.
79 जाएंगे.
77, 78,
79. Day after tomorrow, come with a small written note of submission. That would be easier for us. Go home now and prepare it. You are so experienced a lawyer.
7 days alone, next week any day out, जोटा कि ready है.
I'll put it September, I'll vacate this day.
No, my lord.
Then day after tomorrow. Day after tomorrow.
Day after tomorrow, ठीक है.
Day after tomorrow, you prepare a small matter for you. What? In the matter, same.
Same है भी बहुत ground हो चाहिए. Lordship convince.
Whether those grounds are required to be considered at this stage or not is more important. Let us see. Let us see. Okay. Day after. 81. Okay.
81.
NI Act matter.
Cognizance was taken by the secondary evidence. The complaint was raised. And on the basis of that complaint,
The last occasion, it was the instruction whether it can be settled. So you want to go for mediation.
I had taken instructions from the bank. So the bank says that
You are the bank.
I'm the bank.
Yes.
Since this is a bank under the Cooperative Societies Act, so the registrar is the. They say that the outstanding is around 63 lakhs.
The check amount is 20 lakhs.
2012 is the loan.
You talk about the check amount. You can't recover everything and the guise of this proceeding.
This
138 is not a recovery proceeding. That whatever due he has through this prosecution, you personalize and get the money. That's not the idea of.
They have challenged the cognizance order. What?
That's a different story. We'll go into the merits. Let us see what the merits then. If you don't want to settle.
The allegation is that, my lords, a check was given by me as security in the loan, and when they applied that check, it bounced with the instruction that insufficient funds. Now, while the proceeding was pending, the entire record was misplaced somewhere. Now the record was reconstructed.
Oh,
is that case, Manoj? Lordship was hearing it that.
The original check I had deposited once. The original check was exhibited, my evidence was taken, and then thereafter, the report of the district judge, the district judge,
can be settled, the petitioner.
See, if the originals are stolen, the secondary evidence has to be.
Yes, on the basis of secondary evidence, the cognizance was taken. They have challenged the cognizance order, saying that it is bad.
No, that's my entire thing is that even if it will go back now for trial, it will be limited to that 20 lakhs only.
It will be limited on 20 lakhs.
He is thinking that he will be able to cover the entire amount.
What I also anticipated, Lordship may just hear me, just for a moment. See, even if I proceed with the trial also, I can also, that's what I advise them. And there can be part of compensation if I succeed. There can be compensation or some sort of.
He will file challenge it.
Compensation more than the check amount.
The Lordship may refer them to
Sessions Court. Thereafter, then he'll come to High Court. Then he'll go to Supreme Court.
See, Lordship may refer him to.
By that time, you might have been designated senior, and your son must be handling the case. What is it? Why unnecessary?
It's a cooperative bank. That's the only. The Lordship may refer to mediation. They'll discuss.
Okay. Right on. On the conjoint request of both the councils, and this is a matter arising out of a dispute regarding the division of check of rupees
20 lakhs.
20 lakhs. 20 lakhs. The councils appeal for both the parties express hope that the matter could be settled in mediation. Therefore, to give an opportunity to settle the dispute out of court, I feel it appropriate to refer the matter to High Court Mediation Center. The same order you appear on 7th, 7th you appear, and report will come on 24th, 25th I will take up report.
Interim order to cut.
Interim order to cut. Settle the dispute. He'll give some installment, something he'll give and finish it up.
The difficulty is this, that in cooperative societies, what they have to do now, they have to pursue with the check. After that, they have to pursue with the suit also. So therefore, it's
suit for recovery of the other amount also, na?
Recovery of the interest and everything. So therefore, that was my only predicament.
But today, if you are getting back, it is public money. If you are getting back, you can put to right use. And if you keep on fighting, you will be spending a lot of money on litigation only. And you may get it after 20 years or whatever, I don't know. So better that you should
I'll advise them.
You advise them.
I'll advise them in that.
Advise them.
Grateful.
Yes.
Yes.
82.
Who, my lords? I'm for the petitioner, my lord. In
Yes.
fact, petitioner is interested to settle the matter. But one error he has committed, is honorable court directed to deposit some amount before this registry, but he has not deposited.
What is the case?
Case regarding 138 Act.
What is the check amount?
Petitioner is interested to deposit the entire check amount.
What is the check amount?
Only 62,000, my lord. I'm appealing for the opposite party number 2, my lord.
Deposit here.
Your lordship can
Come to day after tomorrow with money.
Yes, my lord.
My lord, I need only 1 week time.
62. What why 1 week? This is pending since
I have taken instruction.
My lord.
Taken it.
You come with the money, I'll close it immediately. I'll give it and close
Yes,
it.
my lord. I'm ready.
When you tell me. Third. Fifth. Okay, fifth. The counsel appearing for the petitioner fairly submits that fairly submits on the basis of instruction that the petitioner is ready and willing to make good the entire check amount. Lease the matter on 5th.
Interim order, my lord.
Grateful.
83.
83, my lord. I am on the BC, my lord.
Yes.
There is, my lord, the case is, my lord, 138 enacted. Total amount involved is, my lord, 2 lakhs. I am for the accused persons. My lord. I have filed a petition to further cross-examine the petitioner, and that has been rejected, my lord.
The stay is operating.
My lord, the case is, my lord, last occasion, Lordship directed me to take instruction. What is the status of the case? My lord, the case is posted to 5th of August 2026 or record the evidence of the defense.
Defense evidence. Yes, sir. What do you say?
My lord, it is a case which has been initiated in the year 2016, and the evidence from the side of the complainant has been closed in the year 2023. Check amount is 22 lakhs only 2 lakhs, my lord. At the belated stage, they file a petition for recall the PW. Yes, they gave the opportunity.
Okay, I will give one opportunity to him. Let him examine and he will pay you cost.
Yes,
my lord.
Simple.
Yes, my lord. In addition to direct some time frame to dispose of this trial process.
That also I'll do. Where is the impugn order? Where is the impugn order?
Annex of 3.
3.
Page 14. Impugn order is, my lord, 6th of December 2023.
6th?
December 2023.
6th December 2023.
Page 17.
5th December. It is
6th December.
6th December. Okay.
Page
The petition filed and so on behalf of the accused. Today, the case is fixed today for examination of PW1, wherein the advocate for the accused had been to court for getting and business court from so on and not able to present where after completion of the hearing of the response court by seeking for time not for the on the same day you move the application?
Yes.
Same day?
Yes, same day. Now, my lord, I have filed an application of my lord on that is 21/11/2023, and that has been considered on 6th December 2023. Honorable passed on 6th December.
When he was cross-examined? Further evidence on?
And there I was.
The counsel for the complainant filed a memo
on 4th July 2023.
So you want PW1? PW1 or CW1? Complainant.
Yes.
Complainant. Okay, right on. Petitioner is aggrieved. Petitioner is the accused in 1CC case number so and so under section 138 NI Act. The trial of the case is trial of the 150 case is going on since 2016. The evidence of the complainant was recorded on 20th of when recorded on
Recorded on the present. My lord, recorded on
recorded on
4th July.
2023. The petitioner, being the accused, sought recall of the said witness to further cross-examination by moving an application on 21/11/2023, which has been rejected by the trial court by the order dated 6/12/2023. Being agreed by the said order, the present petition has been filed. Present petition has been filed. Heard for the reasons stated in the application, and by taking into consideration the submission made, rival submission made by both the parties, I am satisfied that the petitioner is entitled to a singular opportunity for the purpose of further examination of the complainant. Therefore, while setting aside the impugned order dated 6/12/2023, the trial court is directed to afford a single opportunity to the petitioner to cross-examine, further examine the complainant, being CW1. The trial court, the petitioner shall furnish the petitioner shall conclude the cross-examination or the further examination on the date to be fixed by the trial court. The trial court, it is made clear that no further adjournment in any ground shall be entertained by the trial court. Since trial court, the opportunity to be afforded to the petitioner for cross-examination is subject to payment of the cost of rupees 7,000 to be paid to the complainant. 7,000 to be paid to the complainant. Since the complaint case is was filed on 2016, and the trial has not yet been concluded even after lapse of a decade, it is essential for this court to pass appropriate order in this direction. Section 143(3) of the NI Act is mandate the trial court to conclude the case of origin nature within a stipulated period of 6 months. Despite such mandate, surprisingly, this case, the present complaint case, is going on for about 10 years. Therefore, the trial court is also directed at the same time to conclude the trial of the present case maximum within a period of 3 months hence. 3 months hence. With this object, within 3 months, he will pay 7,000 rupees and do it, finish it up. Yes.
85.
Please, Your Lordship. My lord, here the matter has been amicably settled, Your Lordship.
Settled?
What has happened? He doesn't know.
Who is the other side?
They will not come. What has happened?
I am for the OP4.
Yes, matter has been settled.
Yes, my lord.
Yes.
See again, thank you. Without issuing notice to me, I have no objection. I have annexed that order is Annexure 7. That has been quashed.
What is this case is about?
This is case, Your Lordship, transaction, land I have to give and they have to give me money. So case, counter case filed. Now I have given them the land and the money I have received. It's a purely commercial transaction, nothing remains.
138 case.
No, my lord. This is 406 allegation.
This case is 406, huh?
420 nahi hai, 406. 420 allegation is there, but 406. Annexure 7, Your Lordship, may kindly see, on the basis of this mutual agreement which is filed in the court below, the Honorable Court has been pleased to quash the proceeding which I have. Annexure 7, page 90.
The counter case has been quashed.
I have not been noticed, but I am not object.
Madam, my case may be
this is PS case number 288 of 2024. Yours is?
I am in passing, making a prayer for passing of PS case number 204 by 14/4/2024. That is annexure 5 in the CRLMC.
Pertaining to the same transaction.
Okay.
Two cases, cross cases. One being Cuttack PS case, Sadar PS case number 204, 204 IPC 204, 420 and 34 IPC was registered on 14/4/2024, and the other PS case number 288
288 by 2024
registered on the same date. On the same
different dates.
Registered on
18/5.
18/5/2024. The parties involved in the dispute have entered into an amicable settlement. On the basis of the settlement, the coordinate bench of this court, while allowing CRLMC number 1656 of 2026, quashed the Cuttack Sadar PS case number 288 of 2024 by order dated 21/5/2024 by the Mr. Mishra, Internet Counsel, appearing for the petitioner, has placed on record the additional affidavit wherein the mutual compromise agreement dated 10th July 25 as well as the order dated 21/5/2026 passed by the coordinate bench in CRLMC number 1656 of 2026 includes. He further submits that on the basis of the settlement, the present case may also be disposed of. The additional affidavit is taken on record. Regard being head to the settlement terms and taking into consideration the government made in the additional affidavit, the present petition is allowed. The FIR number FIR number PS case number 204 of 2024 corresponding to GR case number 477 of 2024.
Pending in the court of JMFC Rural Cuttack.
Which is pending before the court of JMFC Rural Cuttack. It's Sarasai. Yes. Quast, sorry, not Sarasai. Quast. 86.
Lord, I am opposing on the ground, my lord. This is a NI Act. The opposite party is a complainant. That amount is 32 lakhs, my lord. Initially, the accused person filed an application to send the disputed signature to the handwriting expert. That was rejected. Against that, preferred a CRLMC. That was withdrawn. Again, he filed an application for sending the check to the handwriting expert. That was rejected. Only again filed this CRLMC.
Only two and only two.
You have obtained a stay, sir.
Only
24 you have taken.
Only to obtain some certificate below.
And my lord, he has
more than that.
My lord, and he has already admitted that this signature is the in the check. The signature in the check is the signature of the accused person. They have already admitted.
Why stay? I don't understand. Why the stay will operate in 130 matter like this? No question of 2 weeks, sir. No question of otherwise I'll vacate the stay. These 130 matters are creating problem. Third, no further adjournment shall be granted. This is the matter on third. It's made clear that no further adjournment on any ground shall be granted. If the petitioners will sought adjournment on that day, the interim order passed on 7/8/2024 shall be vacated.
Obliged.
Third.
87.
Here, my lord, assailing the order below on court below, passing 143.
143.
143A, my lord, to grant interim compensation, my lord, against whom they have preferred this challenge, my lord. Thereafter, notices were issued, my lord. And in the meantime, my lord, only the Supreme Court has said that order is not to be given effect to. Further proceeding is on, my lord. Now the evidence
Further proceeding is going on.
Going on.
What is this case?
Evidence, for evidence it is posted, my lord. And in the meantime, my lord, this honorable court in the coordinate bed, relied upon the judgment, my lord, similar fact and circumstance.
Yes. Which part?
Fifteen, 16, my lord, also. Conclusion part. Paragraph 16,
Concluding
15 and
part.
16.
Paragraph.
Right.
As the complaint case is of 2020. I do not consider it necessary to direct APM to reconsider the matter and consider the interception requested the trial court to dispose of. Yes.
This is also the case of the 20.
Millard,
Case of 2020.
Mane order was passed. Impugned order.
See, in 13/9/2024, the interim order was passed, not
Yes,
giving effect to their 143 order. And this is now 2 years. Trial might have proceeded.
Yes,
Trial has proceeded. The question is that he has challenged the impugned order only on the ground that by that time charge was neither framed nor
143(3). Within 6 months, this has to all the complaint cases to be concluded.
Yes,
and now the judgment has also come.
Actually, in this case, after
I give a direction to conclude the trial within 3 months.
No, my lord, just one second, man. The question is that he did not turn up in spite of repeated summons. Thereafter, bailable warrant was issued against him. Thereafter, NBW was issued against him. He was arrested and produced before the court, and he was released on bail. And actually, he is doing everything to protract the trial.
Therefore,
that is the question.
Therefore, I will say that within 3 months. Within 3 months.
My lord, the statutory provision is that he is to deposit.
But see, 2 years.
20% of the
2 years this remain in effect.
Before this honorable court also, he has filed this case and he is not taking any steps.
Because
the matter is protecting.
Because he got a stay, will not take step, obviously.
The question is that the order is not sustainable on merit and law.
You are absolutely correct. But at this stage, why should I interfere? Rather, I'll give a direction that within 3 months, your complaint case will be concluded.
That is there.
This matter will remain pending for another.
I bow down, my lord. That is there. The only question is that when the statute provides one thing,
you are right.
Let him
I agree with you. I agree with you.
He has taken the check. The presumption is also in our.
You have to take a practical view also. So that is a better idea to conclude and finish it up. Otherwise, I will pass some order and you will go and get a stay somewhere else, and you will be stuck.
My lord, only my submission would be this case is not sustainable. This case is to be.
What do you want? Do you want an adjudication in this issue or the final complaint? Conclusion of complaint you want, or this interim thing?
We are trying our best for conclusion of the trial. We are trying. Complaint is sparing no stones unturned.
I will bound him down that within 3 months it has to be concluded and complete the case. That's a better idea. Because if I'll adjudicate, then he will have a grievance, he will go somewhere else, file some case, again he will be in trouble.
Now he is participating in the proceeding, and in August it is posted below.
Petitioner is accused in 1 CC case number so under section 138 NIA. This 2020, the complaint case was filed way back on No, complaint case was filed on, when was it filed? On the 10/7/2020. 10/7/2020. Then counsel for the complainant respondent submits that the petitioner has successfully prolongated the complaint proceeding by not appearing before the court. He only appeared when the trial court issued warrant against him. Subsequently thereafter, on the application moved by the opposite party, the trial court passed an order dated 28/3/2024, allowing the applications under section 143, 143 capital A of NI Act, directing the petitioner to pay 20%, pay 20% of the 20% of to make 20% of the check amount. The petitioner essayed the order dated 28/3/2024 by filing the present petition. When the matter was taken up by the coordinate bench on 13/9/2024, not only notice was issued to the opposite party, but also an interim order directing not to give effect the order dated 28/3/2024 was also passed. The interim order is in force since last more than 2 years. At this stage, the counsel appearing for the opposite party insists upon this court to decide the petition on merit. However, learned counsel for the petitioner submits that the trial has proceeded in between, and it is in the concluding stage. Taking into consideration the submission made by both the counsels, and taking note of the fact that the trial has already proceeded substantially, I am not inclined to entertain this petition, inclined to enter into the merits of the case insofar as the present petition is concerned. Rather, taking the clue from the statutory provision under section 143 to 143(3) of the NI Act, I prefer to direct the trial court to decide the complaint case within a period of 3 months hence. 3 months hence. The complaint case is pending since 2020. As per the mandate of law, it should have been concluded within 6 months. However, surprisingly, about since last 6 years, the trial of the complaint case is procrastinated. Hence, it has become necessary to pass such an in view of the aforementioned observation, without entering into the merits of the case. The present petition is disposed of to the trial court to dispose of the 1 CC case number 2277 of 2020 within a period of 3 months. 3 months. The trial court shall not entertain the request of adjournment by either party. With this observation, the petition is disposed of. Yes. Yes.
88.
Please, Your Lordship. Your Lordship, I am appearing on behalf of Mr. Devidatta Mahapatra. Lordship, there is no instruction in this case.
No instruction.
No instruction, Your Lordship.
You are supposed to deposit 5 lakhs.
Yes, your lordship. Letter says that he has not deposited. Letter number of the deputy.
What have you challenged?
Your Lordship, I have challenged the cognizance order. Quashing of the cognizance order dated 10/4/2024 in 1 CC case number 2300 of 23.
After the petitioner, by invoking the inherent jurisdiction of this court under 482 CRPC, has challenged the order dated 10/4/2024 passed by the learned STGM, taking cognizance of the offence under section 420, 506, 294, 406 IPC in 1 CC case number 2300 of 2023. The matter was heard at length on 21/11/2024. This court directed the petitioner to deposit rupees 5 lakhs in the court of SDGM Bhubaneswar, subject to deposit of the said amount. The trial court proceeding was also stayed. It was indicated in the said order that after the deposit of 5 lakh rupees, the matter would be referred to mediation center for exploring the possibility of a settlement. Unfortunately, the petitioner has not deposited the said amount. The counsel appearing for the petitioner submits that he has no instruction from the petitioner. In view of the same, the CRLMC so-and-so stands dismissed.
Oblige, Your Lordship.
Yes.
89.
She permits my learned friend is to argue the matter, but I humbly suggest, my lords, can it be taken it tomorrow? It will take some time, right? So final disposal. I understand his anxiety because in trial courts, the case is posted for the bringing of charge.
What is this?
Against a rejection of discharge application. Both the mothers and daughters are before a lordship, and in fact, this pertains to a registration of a particular.
Then it's not good.
That is
all right. Why you
I'm scared of Mr. Mishra. He was
not scared. Yes, last occasion it was very good. At length.
What he says is, whenever he sees you, he is getting hungry.
So,
exactly, you are not right.
I'm scared also. No doubt. It is very thorough.
Let it come tomorrow. Let it come tomorrow, my lord.
Tomorrow may not, because dedicated banks tomorrow may not be possible. Let it be on. Let it be on 5th.
No, 5th it is fixed to 31st. Because it was heard, I had made an assurance with the court below that I will bring final order.
I extend all solidarity.
Actually, on the last occasion, my land friend could not.
I extend full solidarity. That
You ensure the trial court to get final order, dismissal final order? Or?
Any order, either way, I am bound to appear. But he is saying, he is threatening because.
If you assure dismissal order, I'll do it right now.
No, it will.
You need not labor hard.
Dismissal order, it will take some time. There is some material in my favor.
Okay, then 31st. Keep it in.
31st it is fixed, maybe 30th.
First,
30th, my lord.
30th will be again a dedicated bench, therefore.
29th.
29 will.
It is fixed. My lord, that case is fixed. Otherwise, he has.
See, hearing matters, 100 matters hearing.
Also permit me, my application IA is there. Otherwise, it will be prejudging the issue. I'll file an application for adjournment, it will be adjourned.
No, what I'll do is 31st, in the first hour, I'll take it up.
Agreed.
I'll hear you. If I'm prima facie satisfied, I'll pass a stay order.
I will also ask the lordship.
I'll stay then.
I find
No, stay in business.
No, 31st I'll, if you
it will be
I'm satisfied, I'll stay.
No.
Or other I'll dispose it.
It will dispose of birds.
Let us see.
no, my
But don't take much time.
That I am getting
my,
today also.
my lord, kindly attitude. My client is staying at Mumbai. So she has to come. She is a lady. She has to come, leaving all her family members there. So my difficulty is maybe taken up 30th so that she can come. If I do
30th is dedicated. 31st.
29.
Video conference is not
29.
No, video conference is there.
So many matters I have already fixed for.
Lordship permits, she can appear through video conferencing.
Where?
It's not possible.
Here?
No, before the.
Oh, you move application. Who stops you? Video conferencing is allowed.
And if
It is only appearance.
and I also put a word to my colleague there in loud courts.
Yes,
not to,
you should allow the lady. You will do it.
Make an application for adjournment. That much I want, my lord. It's not possible.
Now that will be again, then that will go on and on.
No, it's your lordship. It will be disposed of in the very next day. Because of my land friend, it took time. I have not taken time.
Okay.
I don't.
Das
I'm ready, but with the fire, it's not a case. The far end of the day.
Seeks an adjournment in this matter. Learned counsel, Mr. Mishra, learned counsel appearing for the petitioner submits that matter is fixed up on 31st before trial court. Therefore, he may be allowed to move an application on that day, seeking an adjournment for that day alone. Seeking an adjournment. Let him do so. Let the petitioner move application for adjournment of
That date.
for 31st, 31st of July, and release the matter on now let it be on 12th.
Right, obliged. But item 75 million, you'll also adjourn to inclined to adjourn the 31st. I said 31st. I have some personal. In fact, I couldn't check the diary. The one first is there is another pattern matter, so 31st may be fixed. I'll ask 31st.
31st.
75.
With the cool and
75.
Third, this is on 3rd.
3rd August.
3rd August.
The last item was on 12th. It's okay.
12th. Because on 31st, in any case, he's seeking 1 day adjournment.
12th.
What to mention, Milo? The hearing list, the second list of hearing.
Weekly tomorrow? Tomorrow those matters will be taken up.
Day after
This miscellaneous matter will not come.
Day after tomorrow is dedicated day. Day after Monday, Wednesday, Friday. Hearing.
If I continuously in the next week, Monday,
will not be taken. Only dedicated matter will be taken. He's talking about which matter?
Second
Item?
Second list will not, item 15.
There's second list.
Yes.
15. Criminal appeal, huh? Okay. Prahlad Vera. Take it up. Okay, thank you.
Notice had not solved it. Even order notice.
This matter.
आज बोर्ड रे अछि तो सेटा हम खाली कहि दोछि ताको सेही मैटर रो से खाली
Yes, you soon.